Thank you, Mr. Speaker and members. This is the calendar's rule for the Supplemental Appropriations Bill for Border Security. It contains the same put-and-take provisions as the rule just adopted for HB 5 and routinely adopted for any supplemental appropriations bill. If there's no questions, I move adoption.
The question occurs on adoption of the rule. Does record vote? The clerk ring the bell. Show Mr. Burr is voting aye. There being 106 ayes, 0 nays, the rule is adopted. Mr. Meyer on the floor of the House. Mr. Ashby on the floor of the House. The chair recognizes Mr. Meyer for a motion.
Mr. Speaker, I move to suspend House Rule 8, Section 5D for SJR 2 to designate the following members as joint sponsors: Metcalf, Burrows, Noble, and Sanford.
Members, you heard the motion's objection. Chair hears none, so ordered. Chair recognizes Mr. Meyer for a motion.
Mr. Speaker, I move to suspend House Rule 8, Section 5D for SB 8 to designate the following members: Metcalf, Burrows, Noble, and Shine.
Members, you heard the motion. His objection. Chair hears none, so ordered. Chair recognizes Mr. Meyer for a motion.
Mr. Speaker, I move to suspend House Rule 8, Section 5D for SB 12 to designate the following members as joint sponsors: Metcalf, Burrows, Button, and Guillen.
Members, you heard the motion. His objection. Chair hears none, so ordered. The chair recognizes Mr. Ashby for a motion.
Thank you, Mr. Speaker. Members, I move to suspend House Rule 8, Section 5D for SB 1 to designate the following members as co-sponsors: Metcalf and Rainey.
Members, you heard the motion. The objection. Chair hears none, so ordered. Members, before we begin consideration of today's calendar, I want to remind you of House rules governing decorum and debate, which will be strictly enforced. As a reminder, our House rules were adopted unanimously in January. While you may have strong disagreements on the legislation and policy that will be debated today, our rules require we conduct ourselves in a civil manner and treat our colleagues with respect. Remarks from the front and back microphones must avoid personalities and must relate to the bill, amendment, or motion currently under consideration. Parliamentary inquiries must relate to the business currently laid before the House. Parliamentary inquiries that are hypothetical in nature or in the form of general questions about House rules or committee procedure will be declined. I also want to remind visitors that our rules prohibit outbursts and demonstrations in the gallery. The gallery will be cleared if there are any disturbances that disrupt today's proceedings. Members, thank you for being here today and remaining mindful of the rules that you adopted unanimously. Members, we're about to begin today's calendar. The chair lays out on second reading SJR 2. The clerk will read the resolution.
SJR 2 by Betancourt, proposing constitutional amendment authorizing the legislature to provide for a reduction in the amount of limitation of the amount of ad valorem taxes that may be imposed on general elementary and secondary public school purpose of the residents of the of the homestead of a person who is elderly or disabled and reflect any statutory reduction from the preceding in the maximum compressed amount of that reduction.
The chair recognizes Mr. Murr.
Mr. Speaker, I move to postpone further consideration of SJR 2 until 3 p.m. today.
Mr. Turner, for what purpose?
Would the gentleman yield for a question?
Gentlemen, will yield for a question?
Yes, I'll yield for a question.
Thank you, Chairman Meyer. Why are you moving to postpone SJR 2?
Because I'd like to have it considered after SB 1.
Why is that?
Because I am the bill sponsor, and that is my choice.
Okay. Is it technically the body's choice, though, correct?
Fair, but it's my motion.
Understood. In the House rules, don't SJRs and HJRs, aren't they required to be placed on the calendar before Senate bills or House bills?
That is my understanding, Mr. Turner.
Okay. So you want to deviate from the normal order of the calendars to postpone SJR 2 in order to take up SB 1 first, is that right?
Ms. Turner, I believe you've been in this body a little bit longer than I, and I've seen motions to postpone every session, and this is no different.
Okay. But there's no particular reason?
I provided you my reason.
Thank you. Mr. Speaker.
Mr. Turner, for what purpose?
I object to the motion and request a record vote.
Understood. Mr. Meyer has moved to postpone SJR 2 until 3 p.m. A record vote has been requested by Mr. Turner. The clerk will ring the bell. Have all members voted? There being 83 ayes and 26 nays, the motion to postpone prevails. The chair lays out on second reading SB 1. The clerk will read the bill.
SB 1 by use relating to election integrity and security, including by preventing fraud in the conduct of elections in this state, increasing criminal penalties, creating criminal offenses, providing civil penalties.
The chair recognizes Mr. Murr to explain the bill.
Thank you, Mr. Speaker, members. It's a privilege to be able to be in front of all of you today. I want to give you a brief perspective of some of the history of election law in Texas, simply to provide this in context. So in 1975, Texas passed mail-in voter registration. In 1987, Texas was one of the first states to implement early voting, which allows voters to vote in advance of Election Day at locations other than the precinct polling place. Before 1987, Texans only voted on Election Day. In 1991, 2 years before Congress passed the National Voter Registration Act, Texas passed its own motor voter law requiring that voter registration be offered at DMV sites. And in 1997, Texas ensured that voting machines be accessible to voters with disabilities so that they may vote privately and independently. The point that I make to you today is that Texas has consistently reviewed its election law policy over time, making changes and updates as needed. SB 1 continues this process. Now, while we generally have a couple of years between legislative sessions, we presently are only a couple of months away from our regular session, and this issue is fresh in everyone's mind. This bill today picks up where the House left off, and you will find that it contains many provisions that have previously passed the House during the regular session. Importantly, as I noted previously, during both the first and the second called session during committee hearings, it contains language offered by both Republicans and Democrats, both senators and representatives, during that process. It demonstrates that all viewpoints have been and are being considered, regardless of party affiliation, in an effort to draft sound and thoughtful election policy. Before I yield for any questions, I'll simply highlight on page 2 the express legislative intent that we have in the bill. It is the intent of the legislature that the application of this code and the conduct of elections be uniform and consistent throughout the state to reduce the likelihood of fraud in the conduct of elections, protect the secrecy of the ballot, promote voter access, and ensure that all legally cast ballots are counted, so that Texans can remain confident in a reliable election system. Now, I've heard from and engaged with constituents, stakeholders, and fellow members over the course of both called sessions. I respect every person's and every group's perspective, and I believe that some of the thoughts and concerns have been incorporated in a pre-filed amendment that I filed yesterday. To keep it succinct, this is serious and thoughtful legislation, and I look forward to debating my fellow members on the floor of the House and reviewing and discussing any amendments to it. And Mr. Speaker, I believe there's some questions.
Mr. Speaker.
Mr. Shaheen, for what purpose?
Does the gentleman yield for questions?
for law enforcement to be contacted for those scenarios to exist even today.
And with respect to poll watchers and the concern about them disrupting the process, is it not true that on page 12, poll watchers must take an oath swearing to not disrupt the voting process or harass voters?
That is correct. So the legislation prescribes an express oath that a poll watcher must take as part of the process of being a poll watcher and being appointed by an appointing authority to represent them essentially as their eyes and ears at a voting location.
And didn't you also point out during the discussion of this topic, that current statute forbids a poll watcher from interfering with the process of a voter going through the process of voting?
Yet, actually, current law, and this was brought up several times during committee discussion and the process of listening to witnesses, is under current law, section 33.057 prohibits a poll watcher from being present at the voting station when a voter is preparing the voter's ballot or is being assisted by a person of the voter's choice. In addition, section 33.058 of current law restricts the ability of a watcher to converse with an election officer and prohibits them from conversing with a voter or communicating in any manner with a voter.
Thank you for that. So let's talk about the actual process for mail-in ballots. There was a lot of discussion on that topic during the committee hearing. Can you give us an overview of some of the changes that were made with respect to mail-in ballots, the application process, and changes that were made there?
Yes, sir. So presently in the state of Texas, if you vote in person, whether it's early voting or on election day, Texas requires that you provide some form of identification. And we've heard lots of discussion about what that is, and that includes a Texas driver license or another identification that's issued by the state of Texas for you, or the last four digits of your Social Security number. So this legislation applies those same requirements to the process of mail-in ballots. So if you apply to vote by mail, you are also being required to supply one of those identifying numbers as part of that process. So
you're saying for a mail-in ballot, they can either provide their driver's license number or the last four digits of their Social Security number?
Or they can provide a statement that they have not been issued a number. In addition to the driver's license number, they can provide a personal identification card that's been issued by the Department of Public Safety, and that would have a number on it as well.
So you're saying if they don't have a driver's license and they don't have a Social Security number, that they can just make a statement as such?
Yes, sir, that is correct. That's current law for in-person voting, and this legislation would apply those same parameters to voting by mail. And then I would also point out that voting by mail is not available to all voters. Texas law actually has eligibility requirements for that.
Can you remind us what those are?
To be eligible to vote early by mail in Texas, you must be 65 years of age or older, be sick or disabled, be out of the county on election day and during the period of early voting, or be confined in jail but otherwise eligible.
Are there certain cases where an individual can even use an expired driver's license?
That is correct. Current law allows for you to use an expired driver's license, and in the bill, express language also incorporates that fact.
So in summary, because we've all heard from Texas House Democrats in D.C. that this bill made it harder to go through the mail-in process, but what I'm hearing you're saying is they simply need to either provide a driver's license number, last four digits of their Social Security number. If they don't have either of those, they can just state that they don't, or in some circumstances, they can even use an expired driver's license.
That is correct. And during the committee hearing on this bill, which you are on the committee and you heard from hundreds of witnesses, and we've also seen come out of the Senate, there is cure language to correct a defect on your mail-in ballot that's contained in the bill that you have before us. And also, I'll speak to that a little later with a perfecting amendment as well.
Okay, so tell us a little bit more. So you're saying that individuals have an opportunity to correct a mail-in ballot if there's defects? What kind of defects are you talking about?
Well, for example, if they send in a mail-in ballot and it doesn't meet the requirements so that it can be properly considered, the early voting clerk can actually return that and contact them and let them know that they can come in and correct the application or cancel the application and vote in person. So the point made here is, and also with the perfecting amendment, that we want to make sure that if somebody had an error or mistake, we want that vote validly counted. But we want to make sure that they have ample opportunity to correct what error occurred.
So literally somebody can make a correction after the fact. This legislation allows that.
As long as it's been determined that there is sufficient time to do so before the end of the voting period. Yes, sir.
Okay. It sounds like there's a lot of provisions that make it actually easier to vote, contrary to what we've heard. Contrary to what we've heard, there's been accusations about partisanship and the like, but is it true that there's significant portions of this legislation that are written by both parties?
Yes, and as I explained in my layout, consideration's been given to all members of both the House and the Senate for good policy ideas, and you will see some of those in the form of language that's contained in the document that we have before the body today. And to your point, yes, that contains proposed amendments that were adopted by Republicans and Democrats during the regular session in the course of discussing an election integrity and security bill.
And there's a lot of false accusations made about members of this body and, quite frankly, you. Have you had an open door to any member of this body to discuss this bill and listen to their ideas?
Yes, sir. I have repeatedly indicated to my colleagues that my door is open, my phone is available. I'm always happy to sit down and listen to their concerns, try to answer their questions, along with any constituent or stakeholder groups that they may have that are also visiting with them about this important issue.
One of the things that I noticed is that there was language, former language around quote-unquote purity of the ballot box that was removed. Was that an amendment by Mr. Johnson?
So during the regular session, there was discussion on a similar piece of legislation that did contain a similar provision. And at that point in time, Representative Jarvis Johnson offered a floor amendment to remove that language. And so the language following his amendment has actually been incorporated into the document that we have before us today.
Was there also an amendment with respect to the right for a defendant to be instructed regarding how a felony conviction will impact the defendant's right to vote?
Yes, that is correct, and that is contained in the Senate Bill 1 that's before us today.
And based on my reading, that was an amendment by Mr. Busey, is that correct?
That is my recollection as well, yes, sir.
Was there also an amendment to this piece of legislation by Ms. Gervin Hawkins that gives a voter the opportunity to correct a defect mail-in ballot like we were just talking about? Was some of those provisions that we just discussed, was that actually from Ms. Gervin Hawkins?
Yes, as I identified earlier, we worked hard to pay attention to good ideas regardless of where they originated from this year, and a lot of those ideas percolated to the top during the regular session, and those components were placed into SB 1 that we have before us today.
Was there also an amendment, I believe from Mr. Turner, requires registrars to coordinate to update the address of a voter if they move to another county?
Yes, that is correct.
So there have been multiple amendments to this bill by both parties, including the party that left the state of Texas and accused us of voter suppression and racism. Yet you have amendments from several of those individuals, a lot of their language in this piece of legislation. Is that correct?
Yes, and I'll simply clarify, you mentioned amendments. Those aren't floor amendments that we're considering today.
That's right.
Those were proposed floor amendments on past legislation that we used as a basis to craft the policy discussion document piece that we have today called SB 1.
Yeah, they went through the bipartisan process that we've always exhibited on this floor when any member can either go to the bill author or you can go on the floor and offer an amendment. That process was respected for both parties. Is that correct?
Yes, I believe so. That is correct.
What about the idea, there was a change recommended, and it looks like that it got into the piece of legislation from Mr. Vo that extends protections afforded to workers that allows those who wish to vote to take off work without any retaliation from employers. Is that in this piece of legislation as well?
Yes, sir. And if I may explain, current Texas law actually provides protections for an employee to take off from work on election day. And Mr. Representative Vo's amendment that was made during previous legislation during the regular session is incorporated into the SB 1 language that you have before us today to afford that protection during the entire early voting period. So no longer, if this passed, no longer would an employee simply be protected on election day, but the employee would have those protections from his or her employer during the entire 2 weeks of early voting to be able to take off work and go vote.
So based on the provisions that I've talked about, based on the provisions that came from the Democratic Party, and there's been other provisions, it sounds like, how is this bill suppressing the vote?
I do not believe that this bill suppresses votes.
I don't think it does either. Mr. Murr, I know this has been a challenging time for you. It's been a challenging time for all of us. I really appreciate all the work that you did, the respect, the openness. I'll be voting for this bill. I'm the grandson of immigrants. I would never, obviously, suppress my own vote. This bill doesn't do that. Those are falsehoods. And I'm looking forward to voting for your bill. Thank you for all your work, Mr. Chairman. You've done a stellar job.
Thank you, sir.
Thank you.
The gentleman's time's expired. Mr. Turner, for what purpose?
Move to extend time.
Members, this is a reminder to everyone to be civil and respectful of our colleagues as we debate SB 1. The chair would appreciate members not using the word racism this afternoon. Mr. Turner has moved to extend the gentleman's time. His objection, chair hears none, so ordered. Mr. Turner, for what purpose?
The gentleman yield for some questions.
The gentleman yield for questions.
I yield.
Gentleman yields.
Thank you, Chairman Murr. I have several questions. Your bill includes the word fraud several times, including in the caption and in the bill's legislative findings section. Could you detail for the body how many instances of election fraud occurred in the 2020 election in the state of Texas?
I don't have that information in front of me, although I do know that there were resource witnesses with both the Texas Secretary of State and the Office of the Attorney General during the committee hearing that may have been asked those questions. But the focus of this bill is forward-looking, and if you'll notice when we talk about fraud, at least in portions of that you referenced, it has to do with the likelihood of fraud.
Okay, but you're not able to identify how many instances of fraud may have occurred in 2020?
No, sir, and I don't necessarily believe that fraud is a condition precedent for implementing a good policy.
So the director of the Secretary of State's Election Division, I think you just referred to, stated in committee testimony during the regular session that in 2020, quote, Texas had an election that was smooth and secure, unquote. Do you agree with that assessment?
I agree with that assessment, as I have stated in the past during committee hearings, yes.
Okay. Now, let me go back to fraud. Have you read about or been briefed at any time about the results of Attorney General Ken Paxton's election fraud investigation efforts in the 2020 election?
Only what I overheard during the committee hearing process from witnesses and questions asked of the resource witness from the Office of Attorney General.
So you haven't met with General Paxton or his staff about those findings?
About those findings, no, sir, I have not.
Okay, have you met about other things?
Only in response to specific questions that I have asked, which were very narrow in scope. So I have not touched upon any discussion about that process that they undertook in 2020.
Are you aware that the AG's office, this has been publicly reported, I believe, in the Houston Chronicle, that the AG's office spent 22,000 staff hours on those so-called voter fraud investigation efforts in 2020?
I may have observed that article, but I will take your word for it that that is the statements made in the article.
So the Attorney General's office didn't bring any data to you with respect to their 22,000 staff hour investigation?
Not to my knowledge, no, sir.
Okay. Were you aware that they increased the staff number of their voter integrity unit to 17, which is a total of an additional 8 employees, nearly doubling in size? Were you aware of that?
I was aware of that following questions during the committee hearing process of the resource witness for the Office of Attorney General. Yes.
Okay. And do you know how many prosecutions were a result of all that extra staff and staff hours?
I believe that also arose during the committee hearing process. Off the top of my head, I don't have that in notes in front of me.
Okay. I'll represent that it was a total of 4 prosecutions to date. Does that sound right?
I would not disagree with you.
All right. And so, is it correct that there were, when they looked at instances of so-called fraud, that they in fact found 16 total instances? Again, this is not prosecutions, just instances of fraud they've identified, each having to do with a voter listing an incorrect address on a voter registration form. Is that accurate?
I don't recall that specificity. I will tell you there was some discussion between the difference in the number of individuals versus the number of counts that were raised against them in various different cases. So I'd have to take your word for it. I don't know, Mr. Turner.
Okay. So with respect to your bill, did you or did the committee at any point do any sort of impact analysis, specifically a racial impact analysis, and how this bill could impact voters of color, specifically African American and Hispanic voters in the state of Texas?
No, sir.
There was no impact study done?
No, I was asked that repeatedly during committee by members of the committee by members of the committee, and my answer remains the same, no.
Okay. Why was no study conducted?
I don't know that a study is required, but I'm not aware of any disproportionate impact studies that are currently in existence. Nobody's made me aware, although I have implored my fellow members to share any information that they may have that may be helpful during this process.
But you didn't make any attempt to initiate such a study to ensure that there would not be a disparate impact?
I did not make an attempt to initiate a study, no, sir.
Okay. In the regular session, you'll recall, I think, that there was a lot of discussions about the conference committee report on Senate Bill 7 and some specific provisions that were added into that bill in the conference committee report at the very end of the session. Specifically, a provision relating to overturning elections and another provision that limited Sunday early voting hours that was widely seen as an attempt to target Souls to the Polls programs that a lot of churches run. Do you recall those provisions?
I certainly do recall the discussion, and I recall hearing about those provisions. Yes, sir.
Okay. And are those provisions in this bill today?
No, sir. And if I may expand upon that just a little bit, there are prescribed start and end times during Sundays that you will find in this bill. But I understand that no one has raised any objections that would impact Souls to the Polls. In addition to that, specific language about the judicial overturning of elections without considering or determining how individual voters voted is not contained in the legislation before the body today.
Okay, thank you. So back to those provisions, have we established where those provisions came from in SB 7? And I ask that because I've never heard a definitive answer where those provisions came from. In fact, in a press conference on July 21st, the Lieutenant Governor said that the Senate, he said very definitively, the Senate did not put that in there. So do we know where those provisions originated from?
I do not know where those originated from, and Chairman Turner, I also wasn't part of that process. I wasn't part of the committee at that time, and so I have no background knowledge or idea.
understand. The reason I ask is I think it remains of great concern to a lot of people how those provisions got in the conference committee report on SB 7 to begin with, especially since no one has to date, 3 months later, claimed any ownership of those provisions. So my question is, how can the body be assured that the provisions of SB 1 that we have before us today were not authored or constructed by the same folks who put in those provisions in SB 7 that no one's willing to claim credit for?
How can the body be assured of that today? I think the body can pass a good piece of legislation off the House floor and the Senate concur with it.
Okay, so we don't know for sure then if whoever put in the provisions relating to souls to the polls and overturning elections in Senate Bill 7, we don't know for sure that those people were not involved in writing Senate Bill 1.
I played a role in drafting Senate Bill 1 that you have before you, and I can tell you that those provisions are not contained in this document, and I have no desire for those provisions to be contained in this document. And you ask, how can we have assurance that they won't show up later? And I say one really strong way to do that is for us to not have a conference committee. And we pass quality legislation off of the House floor, and it goes to the other chamber, and the other chamber could concur. And that's one method in which you would have assurance that there wouldn't be any changes made in a conference committee.
Right, and I think my concern right now is simply that if those provisions were written by folks who also had a hand in writing this bill that we have before us today, my question is if that at some point was proven to be the case. And it may not be, but it sounds like we don't have the answer to that information right now.
Well, let me make another distinction, if I may interrupt. I'm now part of this process as the sponsor, and so I wasn't part of that process previously, and so you have an assurance from myself, the sponsor, that I have no interest in seeing those provisions show up in any bill.
If it turned out later that there was a connection between people that helped write those provisions and helped write this bill, do you think that would undermine the integrity of this bill?
I'm not advised, Mr. Turner, as to whether that would, but I can tell you based on this bill and my hands-on experience in being the sponsor of this bill, I'm confident that we're not going to have those provisions in this bill.
Thank you.
Yes, sir.
Mr. Speaker.
Mr. Busey, for what purpose?
Will the gentleman yield for a few questions?
Would the gentleman yield for questions?
I happily yield for questions.
Gentleman yields.
Thank you, Mr. Murr. Just to follow up on that final point, we've seen some amendments that would counter that and would attack souls to the polls hours today. Can we take from your dialogue you just had that you will oppose any amendment that would restrict the hours of souls to the polls?
So may I provide a little background information and context for our colleagues that are listening? So in the legislation that you have before us today, it expands the hours from 5 hours to a minimum of 6 hours on Sundays. There's a Sunday in between the 2 weeks of early voting. And it also puts a start time of 9 a.m. and an end time of 10 p.m. for the local jurisdiction to determine when the best hours would be. And I provide that for
I just
context.
want to make sure you will oppose any amendment that would raise that start time on a Sunday to, let's say, noon, as we've seen amendments filed to that today.
I believe that a start time of 9 a.m. and an end time of 10 p.m. with flexibility in local jurisdiction, as crafted before you today, is the best policy for us to consider.
Let me ask a couple quick questions. I know we got limited time. Under current law, local counties get to decide voting hours during early voting. Are there any restrictions to those hours under current law?
Under current law, it states, for example, for many counties, that a minimum of at least 8 hours needs to be made available.
Sure.
For example, during weekdays.
But it doesn't set what hours those can be.
That is correct. There is not an express prohibition against more than 8 hours.
So counties can set their own hours within the 24-hour realm as they choose under current law. Does this bill take us backwards on the hours that a county can choose to serve?
No, actually, it guarantees additional hours that would be available as minimum hours.
As minimum hours. I'm talking about maximum hours.
So
right now, a county, as we've seen done, can have voting up to 24 hours during the early voting period. We've had questions from our colleague. Does this bill what are the parameters in this bill for during early voting for hours that can be voted?
So, and you've got several points that you make there. Let me try to address one, and if I didn't answer correctly, please ask me again. You mentioned about the 24 hours. I'll point out, and Representative Busey, as a member of the committee that heard this legislation both during the first and the second called session, that you heard resource witnesses from the Texas Secretary of State explain that the concept of 24-hour voting, or more than the 8 hours that was minimally required under current statute, is what was a novel idea that was applied by a jurisdiction during the 2020 pandemic, but has not happened in the past across the state.
But it's allowed under current law to do so.
It is not prohibited under current law.
So we've had people have access to 24-hour voting, and this bill will do what to those hours? What are the parameters?
This bill prescribes a start time and an end time during the early voting period, which is 2 weeks and the weekend in between.
Well, and I appreciate your history because we've all heard celebration about how Texas has such early voting. My point in these questions is, under this bill, correct me if I'm wrong, the maximum amount of time allowed is 16 hours in a day for early voting. Is that correct?
For each weekday during early voting, that is correct.
16 hours. And current law allows up to 24. So we are regressing access by 1/3 of the early voting period. So as I've heard our colleagues celebrate our early voting period, it should be noted that this bill will take away 1/3 of that early voting period. I have one other question for you. One of the goals you set out is uniform and consistent across the state. What are the minimum voting hours in this state under this bill if it becomes law?
The minimum voting hours that are based in here during the weekdays would be a minimum of 9 hours with a window of 6 a.m. to 10 p.m. during weekdays. On Saturdays, from 6 a.m. to 10 p.m. and on Sundays from 9 a.m. to 10 p.m. with minimum hours of 5 hours.
Is that true for all 254 counties?
No, sir, that is not. Current law actually prescribes a breakdown based on the population size of counties, and even a little further when jurisdictions where there is less than 1,000 registered voters. And I know that you're aware of that, because oftentimes that is based on the availability of poll workers, many of which are volunteers, and each jurisdiction has some flexibility to design in this because they are, as a state sets some guidelines for that. We also, there's some deference given to local jurisdictions to design that around the needs and wants of their local constituents.
My concern is, in a bill that's aimed to have uniformity, we're not solving that problem, and our rural voters are not being guaranteed the same minimum of access to the ballot box as our urban and suburban voters, if this bill becomes law.
I disagree with that conclusion. I don't think that we've heard witnesses in rural areas say that they have a limitation of access to the ballot box during their 2 weeks of early voting, the weekend during early voting, and the election day of 7 a.m. to 7 p.m.
Whether we heard it or not, this law as written would have different minimum hours for our smaller counties, thus not inherently guaranteeing them the same hours of access that we give our urban and suburban counties.
Current law already prescribes that in the state of Texas.
It already prescribes that you can give smaller counties less access. I'm just saying, in a bill that's designed to create uniformity, this is an area where we are missing that. So if we bring an amendment, I hope you would consider that.
I'm sorry.
I was saying, if we bring an amendment, would you consider creating that uniformity across the board?
No, sir, I would not. I believe the bill tracks the current framework that we put in place.
All right, I'm going to, thank you.
Mr. Speaker,
Mr. Dutton, for what purpose?
would the gentleman yield?
The gentleman yield.
Yields for questions. Yes,
Yields
sir.
for questions.
Thank you. Let me start by thanking you for meeting with me. I think we met in my office about a couple of hours almost to talk about Senate Bill 1. Let me ask you, when you laid out the bill, one of the purposes that was not in the bill was about increasing access to voting. And the purpose, one of the purposes ought to be to increase voter turnout in Texas. Are you aware of where Texas ranked in all 50 states in terms of voter turnout?
No, sir, Chairman Dutton, I am not.
Well, I've heard that we were 45th out of 50 states in terms of voter turnout during the last election. And it seems to me one of the purposes ought to be in the bill ought to be to increase voter turnout. Would you agree with me?
I would say inherently in a democracy such as ours, we yearn to have every person that has a constitutional right to vote to exercise that right. Yes.
That's right. And so you wouldn't mind if we amended so that the purpose actually would envelop that.
I can find numerous instances contained in the provisions of SB 1 before you today that I believe improves voter access. And
well,
I'm sorry, just let me finish my one statement. And in the legislative intent that we talk about, we actually talk about promoting voter access.
Yes, but what I'm getting at is the purpose of the bill. When you laid it out and you talked about the individual things that involve the purpose, that's one of the things that's excluded. It's not included in the bill, such that, as you said, in a democracy, we ought to have everybody voting. And certainly if Texas is 45th in voter turnout, we ought to be thinking about that in terms of trying to improve that. I mean, wouldn't you agree with me that that's one of the purposes ought to be to increase voter turnout in Texas such that we get people where you have created in the bill, you say access to voting, more access. We ought to make sure that the purpose at least follows that.
And I think I understand where you're going with it, but I go back to our legislative intent of promoting voter access, and I believe multiple provisions here do that. And just because folks have rights, we don't always see them choose to exercise their rights, and I understand that as well. And that can be frustrating for our friends and neighbors because they decline to participate in the process.
Right, but we ought to be encouraging not only the way you get, we could increase the number of hours without creating an increase in voter turnout. And what I'm getting at is while we increase the access, or while we do something about that in the bill, what we don't do is about, in terms of the purpose of increasing the voter turnout in Texas.
You know, Chairman Dutton, that makes me think of a phrase that my grandmother used to tell me, and it's common to all of us, is that you can lead a horse to water, but you can't make him drink. The concept is the same. Just because folks have the right to vote doesn't mean that we can force them to vote.
But you can encourage them to drink. I mean, you could give them salt or something, and they'll go drink. Is the point that my grandfather used to say too. And I heard that. But I just wondered if the purpose, if democracy revolves around all of us participating, we should be involved in trying to make sure and ensure that people actually participate in the democracy by increasing the voter turnout. And that's all I'm suggesting.
And I hear you, and I think that is something that individually you and I take on that task to encourage our fellow neighbors and friends and family members to participate, but I don't necessarily believe that is the state's responsibility to actively force everyone to go vote.
No, I don't mean force. I mean just do something that's creative that helps people access their right to vote. And while you increase the access, as you said, what we don't do, on the other hand, is, at least in the purpose of the bill, suggest or encourage people to go out to vote.
And there's a fine line there between the state suggesting, encouraging, or forcing folks to exercise their right to vote and folks individually choosing to do so. And I think that's a choice issue that we have, and I understand that.
Right.
I guess where you're going with it is perhaps the state becoming some active player in requiring or forcing or encouraging folks to go vote versus us having a system in place and folks choosing to participate in that election system.
Right. Well, actually what I'm talking about is just in the purpose itself, as you laid out, that's in the bill. If we could put in there trying to increase the voter turnout, I think is what I'm getting at.
I understand, and I'm happy to have dialogue with you on that, although
Okay.
I'm not necessarily in agreement right at this moment.
All right, thank you.
Yes, sir. Thank you.
Wait, don't do that, Mr. Speaker. Don't hold it up right there. Well, the gentleman yield for a question.
Ms. Davis, for 1 second. Gentleman's time's expired. Is objection to extension of the time? There is not an objection. Ms. Davis, for a purpose.
Thank you. Will the gentleman yield for a couple of questions just as a follow-up and for legislative intent?
Will the gentleman yield for questions?
I yield to the gentlelady for questions.
The gentleman yields.
Thank you. Chairman Murr, you talked about in the discussion with Representative Busey about the intent is to allow local control or local considerations to help define what the actual hours would be for voting. And I just want to make sure that I heard that right, because from a legislative standpoint, we've been usurping local authority. And so is this bill, is it your intent in this bill that we would not usurp the local authority and in fact allow the local election administrators to define what the hours should be for that particular location?
To answer your question, this legislation builds upon existing statute. Existing statute prescribes a minimum number of hours during the day, during the early voting period, in which a local jurisdiction must have elections available for folks that choose to vote early in person. In addition to that, this bill provides a start time and an end time, and then provides the flexibility for that jurisdiction to choose what time frame will work best for their jurisdiction. So I think what you're finding is we're building upon existing law that the state has already put in place, and that policy has been to provide some consistency because we understand how it's going to be across the board, but at the same time some flexibility at the local level to figure out what works best for the voters that want to show up to vote, as well as the availability of poll workers, volunteers.
And so let me restate my question.
Yes, ma'am.
And I need a yes or no, please. Based on your conversation with Representative Busey, you said you're building on existing law, but that you have allowed the local jurisdictions to define what's appropriate for their area. So my question is whether or not it is your intent that this legislation would always allow for local jurisdictions to define the appropriate hours and processes for their jurisdictions as it relates to setting the framework for early vote.
Yes, it is my intent to allow this piece of legislation to provide local jurisdictions the ability to determine the hours within the framework that is in the statute, that is in the proposed bill provided by the legislature.
And my last question as a follow-up to that, as it relates to this discussion with local jurisdiction, do you envision or do you see where we might come back as a legislature and attempt to usurp the authority that you've given the local jurisdictions? Because we've had bills like that. I just want to make sure it is your intent that that will not happen in this legislation.
Representative Davis, I can't speak to future legislators.
No, I mean this session, legislature.
This legislature, I do not believe that there is an intent to come back and modify things, but I will point out, as I did in my layout, that the state of Texas constantly reviews the election laws that it has to determine what works and doesn't work amongst changing dynamics that we have. So I always think that it is the intent of the legislature to consistently and constantly review policy that's put in place to see if it's working well or if it needs to be modified, changed, or updated.
And there's no question that we have that ability and we do that. I just want to make sure that as we move forward in this legislation, it is your intent that that would not happen in this bill today.
It is not my intent for that to happen today. That is correct.
You.
Yes, ma'am. Thank you.
And Ms. Speaker, I'd like those remarks reduced to writing so that we might have a record of that between this discussion as it relates to intent.
Yeah. Members, you heard the motion. Objection, chair has done so ordered. Mr. Wally, for what purpose?
Would the gentleman yield just for a few questions?
The gentleman yield for questions.
I yield for questions.
The gentleman yields.
Thank you, Mr. Murr. Just to go back to some of the provisions of the bill, just the plain meaning, particularly of some of the language on prohibition of drive-through voting. Are you familiar with the drive-through voting component of it?
Yes.
So are we, in this bill, are we prohibiting drive-through voting in this bill?
And I hate to ask you a question, but just for purposes of clarification, When you talk about drive-through voting, are you talking about current lawful curbside voting that's allowed by state and federal law?
Yeah, so what I'm talking about is particularly in the structure part, right? So what we did in Harris County was, in response to COVID, the county tried to make it simple so that folks who had a fear of contracting the virus had an opportunity to, use a temporary structure to be able to vote. Are you aware of that?
I am aware of that, and there was testimony during the hearings that spoke to that topic.
Okay. And so because in the bill, I think, it talks about structures and it prohibits temporary structures. Is that correct?
That is correct. And do you have a specific provision that you want to point to?
So
just so I make sure I'm on the same page?
I think we are on, excuse me. There we go. Hold on a second. So on page 20, I think it talks about section 3.11 take that back. Section 3.12B, it talks about a polling place established under this section may be located subject to subsection B at any place in a territory served by early voting clerk, may be located inside any building, and then it strikes stationary structures. Are we trying to prohibit a particular polling location that may have set up a tent next to the county building? Because I think this is the county building. Is that my understanding?
So section 3.11 relates essentially, and if you talk to the Secretary of State, relates to the clerk's office during early voting.
Right.
Section 3.12 relates to any other voting location during early voting. And the purpose here is to explain that voting needs to occur inside the building. And if you go back to the premise or the policy argument behind it is, we've heard several folks speak about the constitutional right to vote and how we hold that as very important. Protecting the secrecy of your ballot and providing you a place to do that in private is very important. When you locate that process outside of a secure place where it's not necessarily available to you, then there's a potential that your ability to vote is not in private and may be compromised. And so that's the purpose. Okay. So I just to clarify, because I certainly don't want to be coy with you, this bill explains that the right to vote from your voter vehicle exists under the current rights prescribed for curbside voting. And curbside voting is limited to those that are eligible to vote for curbside voting, but it's not provided to all persons. And this bill doesn't expand upon that.
Right, but I think the effect of what we did in Harris County with this bill, particularly for folks that had a credible fear of contracting the virus, that they were allowed to vote in their car, very conveniently, vote in their car so that they wouldn't contract the virus. Because part of the impetus for what we did in Harris County was that we were trying to protect public safety. And one of the reasons we, expanded curbside voting, expanded 24-hour voting, and allowed folks to have an opportunity to have, particularly just the mail ballot application be sent to voters, which initially was subsequently backtracked, was to allow folks easier access to the franchise during the pandemic. You're aware of that? Is that your understanding?
I'm aware of that, and I think you've got two topics here. If you want me to talk about curbside voting, or if you want me to talk about the application to vote by mail. I mean,
no, so I'm talking about all of it, but
yes, sir.
It pertains to curbside voting, because what's happened in Harris County was that we did some, use your term, some novel creative ways to access the ballot, but in this bill now prohibits it by prohibiting drive-through voting and 24-hour voting, and so that, and temporarily early voting locations that are not located inside a building. So I'm just trying to make sure that we understand that and the public understands what's going to happen with this bill once it is implemented.
Yeah, and I will clarify for you that this bill provides that a person can vote from their automobile pursuant to section 64.009 if they're physically unable to enter the polling place without personal assistance or likelihood of injuring the voter's health, which is what we currently use as curbside voting.
Okay.
And so it doesn't touch that, and it's also protected by federal law, but it doesn't expand upon the ability for you to vote from an automobile if you don't meet the criteria of current curbside voting, which I get to is maybe that was a novel approach that was tried in Harris County. It's not expansive to include that for every person. They still need to meet that criteria of 64.009.
Got it. I want to turn to page 37 of the bill as it relates to unlawful solicitation and distribution of an application to vote by mail. Page 37. And
Page
so
37.
in the bill, would you say that we are creating a new criminal offense in this section?
Yes.
Okay. And would that be a state jail felony?
Yes.
Okay. And could you describe what, in the bill it talks about Section A, public official, an election administrator, not to be coy with you, but an election administrator would be a public official, is that correct?
I'm gonna clarify that. I have a perfecting amendment in a minute that actually brings that term in, because a public official may not necessarily include a non-elected elections administrator. And so my perfecting amendment would include that in the definition.
Okay.
So assuming that the perfecting amendment later is considered and adopted, then the answer would be yes, this provision would apply to a public official or an elections official.
Okay. And so with that in mind, just using, without your perfected amendment, a public official now, if they choose to send or solicit the submission of an application to vote by mail from any person that did not request it, if they should choose at their discretion to send just, not the ballot, but just the application to vote by mail, that would be an offense and up to a state jail felony. Is that correct?
That is correct. The language here expressly states that they're not supposed to send it to someone who didn't request it. Now, alternatively, the policy goal here, and I've explained this in committee, is our system is designed upon activity by the voter. The voter has to request it. And therefore, the voter is watching for what's coming in the mail and paying attention to that important piece of mail, that application to vote by mail.
Okay, so the voter then now has to, without, but in this section, we are creating a new criminal penalty up to a state jail felony for a public official who sends this application unsolicited to a voter.
That
Any
is
voter.
correct. Yes,
Okay.
sir, that is correct.
Okay.
And I just go back, the policy goal there is Texas, its policy is passive. A voter has to request that application to vote by mail. We are not an active or proactive state policy of distributing all of those to everyone all the time. And so that's what this is following.
Okay, I guess, could you explain that a little further? Because I'm trying to understand why we would make a policy decision to make it a state jail felony to encourage folks to, for all intents and purposes, participate in the franchise. Anybody, any Texan, whether they're Democrat, Republican, or Independent, disabled, why would we do that?
So some of the testimony that we heard during the committee hearing process, as well as input from stakeholders and individuals, raised concerns that if a potential voter is not aware of the document that's headed their way, then, and I go back to our legislative intent, you have a scenario where you could have the likelihood of fraud because that application to vote by mail has been sent out. They're not aware of it. And we all know that outside the ballot zone where you vote, you know, you're gonna have paperwork that's coming and going. And so at the end of the day, the policy is for it to be a passive system.
So you said likelihood of fraud. That was a key word for me. What do you mean by likelihood of fraud? Are we implying that because somebody gets a unsolicited application that there's going to be a likelihood of fraud?
No, I'm going back to the legislative intent where we talk about the purpose is to reduce the likelihood of fraud. And when you vote in person...
What would be the likelihood of fraud?
If I may, when you vote in person and you go in person and you vote, your ballot never leaves the voting location. When you vote by mail, your ballot is, first you're going to have an application to vote by mail with potentially confidential information that's going to be returned, and then your ballot by mail is going to be sent out, and it's also going to be returned. And so because that ballot is unaccompanied compared to in a scenario where you go to a polling location and your ballot is, there is a potential, as we've heard from input from folks, that there could be a likelihood of fraud. And so but efforts made to ensure that our policy protects against that works to ensure security in the overall system. And that provides...
But what I'm trying to understand, though, is this is just the application itself, not the actual
That is
ballot.
correct. Yes, sir.
So where in that process of an elected or appointed, future appointed official, public official, how do we not trust that person, usually a person that's a career official, to just send the application itself to the voter? It's not the ballot itself, it's just the application for them to have the opportunity to get the ballot. Where in that process is there a likelihood of fraud being committed?
I believe I've answered that. And that is the fact that unlike voting in person, where your ballot is contained in the environment that we hold sacrosanct, voting by mail, and thus your application to vote by mail, includes personal information, and it also has to do with your ability to exercise your right to vote. And so it should be initiated by the voter. But that's the policy goal.
Since the inception and up till now, my understanding is I'm with you. That is a sacred, the right to vote, that secrecy, being in a booth and having that opportunity to vote is sacred. But it's just as important for somebody that's maybe a senior, maybe a veteran, maybe disabled, to have that same opportunity in their home, to have that ability to at least just receive the actual ballot application, let alone the actual ballot, but just the application itself.
And they have the right to receive that application as soon as they request it.
Okay. And then the following page, on page 38, section 276.017, unlawful distribution of early voting ballots and balloting materials. We're also making it, and I'll just read it verbatim: the early voting clerk or other election official commits an offense if the clerk or official knowingly mails or otherwise provides an early voting ballot by mail or other early voting by mail ballot materials to a person the clerk or official knows did not submit an application for a ballot to be voted by mail under section 84.001. The section right under that is creating an offense under this section as a Class A misdemeanor. Is that your intent in that bill as well, is creating a Class A misdemeanor on this offense?
Yes, sir, you have read it correctly, and yes, it does create a new criminal offense.
Okay.
And that criminal offense is of no concern if the early voting clerk or other election official follows the law and does their job. It has a knowingly requirement, so they have to know.
But you're also creating another penalty for election officials who send out early vote materials, balloting materials as well?
That is correct.
Okay.
To someone who didn't request it, that is correct.
Okay. Thank you.
Mr. Speaker, will the gentleman yield for some questions?
Certainly yield.
Does the gentleman yield?
Yields for questions.
Thank you, Chairman Murr. Just wanted to run through a few questions and really kind of follow up on what Representative Wale was discussing with respect to voters in Harris County who had used the drive-through vote centers during the 2020 election. Do you recall that the Harris County Election Administrator testified before the committee during a hearing on SB 7 and HB 6 that approximately 53% of the votes cast at the 10 drive-through sites available during the 2020 election were by people of color? Are you familiar with that data point?
I was not present during the testimony during the regular session of the committee hearing, so I will defer to you in assuming that that data point as you describe it is accurate.
Yeah, of the 127,000 voters, Republicans and Democrats, who cast ballots via the drive-through centers in the 2020 general election, keeping in mind that we were in the middle of the deadliest pandemic of 100 years, or in 100 years, 53% were voters of color, so it's approximately 67,310 people. Why is that method of voting, why does that increase the likelihood of fraud in your view? Or does it increase the likelihood of fraud in your view?
In order to answer your question, I'll point to some of the testimony that we heard from witnesses during both the first called and the second called sessions, committee hearings, talking about the fact, and you heard us earlier talk about the sanctity of our ability to go into a private space in the voting or polling location and cast our ballot in private. Once you remove yourself from that polling location and now you are in a more public area, for example, in an automobile, perhaps surrounded by other people, your ability to cast your ballot in private is not as easy to do.
How many voters complained that they were concerned about the secrecy of their ballot when using this process?
I believe that I don't have a number in front of me, but we did hear some witness testimony that exhibited some concerns about that process.
From the voters themselves?
I don't know. I don't know if they were voters that tried to use that process or not.
In other words, did the voters ever complain about their secrecy being infringed upon, or were there third parties that said, well, this is a concern?
I am not advised.
Okay. But you referred to the testimony both during the first regular session that you admittedly said you were not, that you did not sit in on, and also the special session. Is that right?
The regular session I did not participate in. The first called and the second called sessions, committee hearing testimony, yes, I did participate in.
Why would we be punishing local elected officials during the deadliest pandemic in 100 years for using these drive-through vote centers? Why would we be punishing them with penalty enhancements?
I do not view it as a punishment. I do believe that efforts were made, perhaps with good intentions, to skillfully and artfully interpret the election code to try to arrive at methods that they could then apply during a pandemic scenario. I understand that.
And you believe it was in good faith to sort of mitigate the spread of a deadly virus?
I have never encouraged that it was in bad faith.
Okay. So back to my original question, how does that increase the likelihood of fraud, which was the language that you used, and I think the language in the bill?
And as I just mentioned to you, the moment that you have the activity of voting occurring outside the polling location, which, as you well know, the election code spends a great deal of language providing the safety, security, and privacy that we all yearn for when we're making our decisions, that becomes more of an open process if you're out in a
But you're unaware of any instances, as you just testified, where either secrecy was adversely affected, where a voter said they were worried about the secrecy of their ballot, or cases of fraud specifically with this method of voting?
Mr. Anchia, I'm just not advised.
But you're unaware?
I'm unaware at this time, yeah.
Okay. And so penalty enhancements are usually designed to achieve a deterrent effect. What are we trying to deter here, other than, as you said, local elected officials in the middle of a deadly pandemic trying to facilitate exercise of the franchise while at the same time keeping people safe? What are we trying to deter by penalty enhancements?
By penalty enhancements, okay, you have two parts there. The steps that they took during the pandemic, for example, were not steps that were taken statewide in various different jurisdictions. We'll call them counties. And so that's one part of your question there. And I go back to the concept of uniformity and consistency across the state. So you, as a voter, you prefer to see some standardized or equal treatment of the voting process across those jurisdictional lines, and that's up to a policy decision by the state to do.
Are
and then separately, you're talking
254
about
counties
penalties.
equal? Are they made equally, geographically, population-wise?
I've never said that they were all equal.
Okay.
So I'm not going to say that Dallas County and Harris County and the rural counties out west are all equal. I understand that
But you feel that a sparsely populated county that may have 100 people, or 200 or 300 people,
Loving County has 62, I think.
should be treated the same as a county with 3 million people.
They should have an expectation of uniformity in the application of the election code.
And how does that further how does that equal treatment of different circumstances, especially during a pandemic, further the policy goal of reducing the likelihood of fraud?
You ask a broad question. I'll go back to consistent application and uniform application of our election code.
How does that uniformity and that, because you're making a policy choice here, you're saying, hey, uniformity is important, despite the fact that we know that counties are completely different. Uniformity is important, and we want to impose that uniformity despite the difference in counties. How does that achieve the policy end, which you've articulated that is the goal of the bill, in reducing the likelihood of fraud?
And reducing the likelihood of fraud is not the only policy goal that's articulated in the bill. And I know that you're focused on that.
How about that one specifically?
So I understand that, but I'm also going to remind you that it also contains language regarding the protection of the secrecy of the ballot and promoting voter access to ensure that all legally cast ballots are counted. So when we talk about...
How does it promote voter access?
Well, when we talk about voting from vehicles, I think a lot of effort and focus is given to protecting the secrecy of the ballot, which was what I was speaking to earlier.
But you also said that there were no instances that you were aware of a voter who said that the secrecy of their ballot was somehow impacted by this mode of voting, right? You said there may have been third parties who suggested that, but never a voter who complained to you or to the committee.
I didn't say one way or another. I'm just not aware of that information.
Okay, so you're unaware. So how does banning this during a terrible pandemic further either the likelihood of fraud goal, the access to the ballot goal, or the secrecy of the ballot goal?
So you go and you say ban. This is an emphasis on what was understood to be current law more prior to the pandemic. So prior to the pandemic, everybody's expectation was the ability to vote curbside from your automobile under current law, which is also protected by federal law. That was expounded upon by interpretations of one or more local jurisdictions. This simply comes back and explains that that's not how election code has operated in the state of Texas.
And where was that interpretation that this activity was prohibited? Where is that interpretation? Where's that found?
The only place in the election code that I'm aware of that speaks to the ability to vote from your motor vehicle expressly is section 64.009, and that has to do with what we refer to as our curbside voting, and it actually has a reason that you have to exhibit for that. It's not universal in nature.
So back to my original question, the three precepts, I guess, or the policy goals that you're trying to achieve in this bill are secrecy, are reducing what you said, the likelihood of fraud, or access to the ballot. How does this policy decision that you're making further those goals?
Okay, I'll just be clear, because I've tried to answer your questions. Can you hone in specifically? What are we visiting about?
I apologize. What Harris County did with respect to these drive-through voting modes that you are seeking to prohibit the use of on a go-forward basis.
Yes, and so I will articulate. Let me generically refer to that concept as universal voting from your vehicle for purposes of that, or universal curbside voting. And that's
or
what
at least, at the very least, we could narrow it and say during a pandemic, right?
Well, we'll just call it
when it was used.
Universal curbside voting. And I believe that we heard testimony, and I articulate to you today that it protects the secrecy of the ballot to say that, you know, we're not here to let every person vote from your car when you're perfectly able to go into a secure polling location and vote in the framework that we set up for a secure ballot. We provide the voter access for the folks who have trouble actually leaving their car. So we currently have that framework. And then if you're going to have folks that utilize some type of universal curbside voting, the ability to know whether or not that is subject to abuse, I don't know. We didn't hear a lot of testimony on that.
Is that secrecy of concern with respect to drive-through voting that is currently permitted under the law?
We didn't hear, I wasn't aware, and I didn't hear witness testimony speak directly to that. Typically, it was more on the topic of the universal curbside voting that you have mentioned in your questioning.
So you're unaware of any voters who are concerned about the secrecy of their ballot in the Harris County model, what you might call universal, and you haven't heard any concerns about secrecy with respect to traditional drive-through voting. Is that a fair statement?
I'm just not advised, so that's a fair statement.
Okay, super. You talked about the how Texas has been a leader in access to the franchise in the past. At the beginning of your layout, can you recount the different things that we have in Texas law and the dates when they were adopted?
And this is just a snapshot, so please don't think this is all inclusive.
I'll stipulate that it's a non-exhaustive list.
Thank you. In 1975, Texas passed mail-in voter registration.
What was the year?
1975.
Okay.
In 1987, Texas implemented early voting. And that's what we talk about. 1987. That's what we talk about when we speak of the 2 weeks of early voting that we are accustomed to, along with the weekend of early voting.
Okay.
Prior to that, it was just election day.
Okay.
In 1991, Texas passed what it was referred to as a motor voter law, requiring that voter registration be offered at what we now call DMV locations. And in 1997, Texas ensured that voting machines be accessible to voters with disabilities.
Disabilities.
Yes, sir. Okay. And those are just examples, but they're certainly not an exhaustive list.
And they're laudable examples of expanding access to the franchise, right?
Pointing to efforts by this body made for the benefit of the voters of the state of Texas.
Okay, thank you.
Yes, sir.
Members, the gentleman's time has expired. We are about to move on to amendments. Once we move on to amendments, questions in general about the bill will no longer be in order.
Mr. Speaker.
Mr. Rosenthal, for what purpose?
I would move that this entire substantive debate at this section of the bill be reduced to writing and entered in the journal. I thought it was very good.
Members, you've heard the motion. Is there any objection? Chair hears none. So ordered. Mr. Anchia. following amendment. The clerk will read the amendment.
Amendment by Anchia.
Chair recognizes Mr. Anchia.
Thank you, Mr. Speaker and members. I do appreciate the opportunity to share ideas and experiences about policy goals with Chairman Murr. This amendment is very straightforward. It's very simple. It will preserve the freedom to vote for millions of Texans. It will allow local elections administrators to employ strategies during the deadliest pandemic in 100 years to maintain public health and at the same time protect access to the franchise for people who are worried about contracting COVID. Members, I am convinced that because our elections were safe, secure, and successful, that we are not here really to deal with what I might term the pretext of the policy goals of incidents of fraud or likelihood of fraud. The bill author was unable to point to any. The prior bill authors were unable to point to any. And in fact, we know that the likelihood of fraud in a Texas election is a rounding error of a rounding error, maybe even of another rounding error. It is so infinitesimal, so as to be a lower percentage than even being struck by lightning. Yet, the governor declared it an emergency item. We had a first special session. We now are in a second special session, and why? And during the regular session, I pointed out and drew a direct line between why we are here today and the big lie that was offered by our ex-president, who said that the election was stolen from him, despite no evidence to the contrary, who suggested that African Americans and Latinos in urban areas had somehow committed fraud so as to not deny him a second term, never taking any personal responsibility for why he actually lost the election. And it was suggested, again, that Republicans need to stop the steal. That language led to an insurrection against the citadel of democracy, our U.S. Capitol, where I got to spend a lot of time with my colleagues trying to defend the very delicate democracy that we have. An insurrection where the vice president was to be lynched, where members of Congress fled for their lives, Republicans and Democrats, and where the peaceful transfer of power that has been a hallmark of our democracy was threatened. And in fact, now we are learning that it was an attempted coup that was only stopped by members of the military who refused to go along with this big lie. Members of our military who were brave patriots, who believed in this country, believed in the sanctity of elections, and believed in the rule of law, who would not bend their knee to any politician who tried to offer the big lie as a pretext for taking away people's voting rights, for overturning an election, for overturning the peaceful transfer of power. And I can draw a straight line from that to the bills that have been filed all over the United States to try to make it harder to vote. And I'm sorry that when we talk about discriminatory impact, it bothers people. Those are not my words. Those are the words of independent federal judges across this country when they've seen what this legislature has done to voting rights over the last 10 years. And I was really happy to hear from the chairman that Texas over and over and over again has tried to expand the franchise, keeping in mind that we have not had a pluralistic democracy
for most of our country's history. It was not until 1965, when President Johnson, a Texan, signed the Voting Rights Act, that we had full participation in this democracy. And it is now the same people who were empowered by that Voting Rights Act who are having to stand up for democracy at this moment. Because as much as you might decry our need to go to Washington and really beg for federal protection, I will let you know that while in 1975, as Chairman Murr said, in 1987, in 1991 and 1997, there were expansions of the franchise in Texas. That's what not when the current party in power was in power, was it? And that's just the facts. We had the Voting Rights Act in 1965, and we started to expand the franchise in 1975, 1987, 1991, and 1997. Things don't just happen, people make them happen. And so I want to remind you, since we were reminded of that good history on voting rights, I want to remind you of recent history, since Republicans have been in control. And this is not old-timey sort of Bull Connor, hoses and dogs. This is contemporary. This is digital. Many of you have been in the legislature during these times, like in 2012, where the judges in Texas v. Holder on redistricting said, in rejecting the argument from the state attorneys, the court said the maps adopted by the legislature had the effect of denying, abridging the right to vote on account of race, color, or membership in a language minority group in violation of the Voting Rights Act. In Texas v. Holder, photo ID on August 30th, 2012, the judges said, quote, a law that forces poorer citizens to choose between their wages and their franchise unquestionably denies or abridges their right to vote, the opinion said, adding that the law was intentionally, not accidentally, intentionally discriminatory. So because the author has offered up this history of expanding the franchise in his bill layout, I think it is also important to remind the body of the recent history of restricting the franchise. Like on October 9, 2014, in the V. Perry case, also related to photo ID, the court holds that SB 14 creates an unconstitutional version on the right to vote. It has an impermissible discriminatory effect. Perez v. Abbott, redistricting, March 10th, 2017, plaintiffs have established a Section 2 violation. And, quote, the desire for partisan advantage leads the legislature to select a course of action, at least in part because of not merely in spite of its adverse effect on identifiable groups. Perez versus Abbott, redistricting, 2017. There was intentional discrimination, and I could go on and on and on. So it is against that backdrop, members, that we find ourselves today, against the backdrop of the big lie and against the backdrop of recent history of this legislature, the record of this legislature. And I know people sort of bristle at certain terms that are used, so I'll just say that have been intentionally discriminatory. Intentionally discriminatory. And so, members, this bill, there's no reason for this bill. And no reason why we had to come back, and no reason why you had to be here. This is all about furtherance of the big lie, and I want you to think for a minute, with no examples of voter fraud. Are the principles that are being offered by this bill, do they hold up to scrutiny? Is that uniformity pretext? Does that hold up to scrutiny? Does the incidence of fraud, which is a rounding error, hold up to scrutiny? And does that expansion of the franchise hold up to any scrutiny?
Ms. Hinojosa, for purpose.
And I would say no.
Does the gentleman yield for a question?
I would say no. And I'd be happy to yield for questions from Representative Hinojosa.
He yields for questions.
Thank you, Chairman Anchia. You spoke very eloquently
Thank you.
about the disproportionate impact of this legislation and prior acts of this body, when you speak about the disproportionate impact, are you talking about a disproportionate impact on people of color?
Specifically, courts have pointed out over and over and over again intentional discrimination against African Americans, intentional discrimination against Latinos, intentional discrimination against people of color. These are not my words. These are 3 federal courts across this country making 10 findings of that intentional discrimination.
Intentional discrimination against people of a certain race, is that racism?
That is...
Ms. Hinojosa.
Those words, intentional discrimination, I think can be fairly characterized in that manner.
We can talk about racial impacts of this legislation without accusing members of this body of being racist.
Respectfully, I'm not accusing members of this body. I'm talking about...
Members' outbursts are inappropriate. Ms. Hinojosa?
Will the gentleman yield for questions?
Gentleman
More
yield for
questions.
I yield for questions.
Chairman Anchia, when there is an act that is intentionally discriminatory against people of a certain race, is that racism?
I think when you are acting in a way that is intentionally discriminatory, and I will use the language of courts that have, since I've been a member of the legislature, in VC v. Abbott, with respect to strict photo ID that was ultimately overturned, they said that the legislature knowingly placed additional burdens on a disproportionate number of Hispanic and African American voters. And I think that's pretty clear.
The gentleman's time has expired. Mr. Wu, for what purpose?
Mr. Speaker, would I move to extend the gentleman's time?
Members of objection to extending Ms. Anchia's time? Chair hears none. The gentleman's time extended.
President Anchia, early on in the beginning of this layout, the bill author talked a lot about the different times that this legislature and this state has expanded voting hours, early voting, and all those different types of things, right?
Yeah, I think the bill author talked about expansion of the franchise in 1975, 1987, 1991, and 1997. And what I tried to contrast there was efforts to restrict the franchise during the last decade alone.
Those are all things that were done under Democratic administrations, right?
It is my recollection. There may have been a Republican governor that served, but usually a legislature that was democratically controlled.
And the bill author talked a lot about...
And can I add one more thing,
yes,
Representative Wu? Voting rights never were partisan. I mean, this is such a recent phenomenon. The last time the Voting Rights Act was reauthorized, it passed 98-0 in the U.S. Senate. It passed with broad bipartisan support, and under a Texan, a Republican Texas president, George W. Bush. It has never been partisan up until the last decade, and I don't understand it.
Yeah, I don't understand it either. And the bill author laid out, there's provisions in this bill that were offered by Democrats that would do something to help make this bill better, correct?
Yes, that was the chair's layout. I'm unaware of the specific provisions, but I will take his word. I will take his word for it.
But just because there are individual provisions in this bill that are good does not mean there are some really bad provisions that it's trying to hide.
Of course.
And does a piece of legislation, does a law need to specifically outline intentional racial discrimination for it to have a discriminatory effect?
It never says in the bill, and I have a copy of the bill with me, it never says in the bill, this bill is designed to discriminate against people of color. It never says that. In none of the bills that have been struck down by federal courts did it ever say that. So when I always find it curious when proponents of the bill say, well, find one place where it says voter suppression in the bill. It never does.
That's the point, isn't it? Isn't that the point?
That's the whole point. That's the whole point. And when we don't, especially in light of that history that I detailed, when we don't talk about, or when we don't engage in any sort of analysis related to potential discriminatory effect, we leave it to the courts to find those things, and they found it on 10 different occasions. And that's why they overturned the strict photo ID bill. That's why they overturned the gerrymandered lines of 2011. And I think it's a damning record.
And earlier on, you talked about, you gave us all these quotes about how this body intentionally and directly place restrictions on minority groups, on minority racial groups, minority language groups. That wasn't you saying that, right?
No, I didn't make that up.
That wasn't me saying it.
No.
Who said those things?
Federal judges, Republican appointees and Democratic appointees, including a 3-judge panel in San Antonio that had 2 Republican appointees and 1 Democratic appointee.
Thank you, Mr. Anchia.
And I would add just one more thing, Representative Wu, in response to your question, that I'm sorry that some people get triggered when you talk about intentional discrimination, and people get upset about that. But one need only read these court opinions, and court opinions shouldn't really trigger anybody. I mean, the bottom line is that is the record. So when people come up here and say that this bill is really about A, and then you ask them, like, okay, it's about the incidence of fraud, where are the examples? And they say, well, yeah, I'm not advised. In light of this history...
Mr. Speaker, will the gentleman yield for a question?
Not at this time. In light of this history, you should take a negative inference. I do. If this isn't about expanding access to the franchise, if it's not about the already very low incidence of fraud and where you're not advised of any examples, if it's not about the secrecy of the ballot box because no voter has complained, then my inference is like, well, it may be about the same stuff that those other bills were about. And that's why I think it's relevant to discuss today. And I'm happy to yield to questions, for questions.
Will the gentleman yield?
Gentleman yields for questions.
Yes.
Thank you, Mr. Representative Anchia. I heard you several times. You've said the intent of the bill is not valid. You mentioned something about there isn't fraud. I heard you several times during this discussion say, not my words, but somebody else's. And I also heard that dialogue between you and Representative Wu. But I want to remind the body of some things you said in 2011 that were specifically your words.
Oh, I've been waiting for this moment for a long time.
I bet you can't wait for this.
And
the type of voter fraud that's been seen most prevalently in the state of Texas is mail-in ballots. 70% of all the prosecutions by the Attorney General are mail-in ballots. And you kept going on, and then you said, you said, we will be reading about mail-in ballots fraud, mail-in ballot fraud, and mail-in ballot fraud. These are all your words. You also asked why
can I offer you some context?
You also asked why. I read about the whole context.
No,
here. It's right here. And
it's not a question. So I'd like to offer you some context because.
Well, I read the context, and you're validating that there is indeed fraud in Texas. And here you're trying to tell the body that there isn't, and I think that it's disingenuous, and it's really unethical.
Let me tell you what is disingenuous, sir.
That's disingenuous.
When you take a speech.
It wasn't a speech. It was a dialogue.
14 years ago. On this very mic, and you boil it down to, I don't know, a dozen words, and you take those words to try to prove your point. Let me give you the context behind that, because I think that was intentionally misleading. One, mail-in ballot fraud, even then, was rare. And a rounding error of a rounding error. What was exempted from that speech...
You said 70% of all prosecutions the Attorney General done are mail-in ballots, and you repeated yourself in your own words 3 times.
I'd like to finish my answer, please. 70% of 1 is still 1. 70% of 10 is 7, okay? And that was over a period of time. What you need to understand about that context is the strict photo ID law, just like the law that is being offered today, was offered with no evidence of impersonation. The only evidence that we had, albeit minuscule, was in mail-in ballot. And it was minuscule.
Representative Chia, I disagree. I read the whole dialogue. I read the entire dialogue.
I'd like to answer your question.
I disagree. I'm going to go sit down and let you explain to everybody.
But I'd like to answer your question.
Members, let's not
you're
speak
not
over
permitting
each
me
other.
to answer. You're over-talking me. and you're not asking questions. So I'm going to answer your question now that you walked off the mic, and I'm going to look right at you. And so you have to understand 4 concepts. 1, voter fraud in Texas then and now is virtually non-existent. Where there have been incidences, these rounding errors, it has been in mail-in fraud. This bill is not about photo ID, which was offered up in the videos that were selectively excerpted. And the parts that were taken out of that video, very conveniently, where you only focused on 14 words, was where I said mail-in ballot or voter fraud was virtually non-existent. Then, it's virtually non-existent now, and it is intellectually dishonest for people to try to take 14 words out of a broader speech and try to prove your point with it. That is intellectually dishonest. It may be okay for Twitter. You might get some likes, and that's okay. But when you take out the parts of the speech that say there's no material voter fraud in the state of Texas, and where I say I know that this bill is not about voter fraud in the state of Texas, and you excerpt that and only take the part that is favorable to your position out of context, I think that's unfair. So I'm really glad that Representative Tinderholt asked me about that in the form of a question, so I was able to provide that context, because that was really not intellectually honest.
Would the gentleman yield for questions?
The gentleman has 30 seconds left, Mr. Wu.
I'm happy to answer questions.
He yields for
Very
questions.
quickly. One of the things that the bill author said was, the bill sponsor said, was that a lot of these provisions were put into place, that the election judges and people did, was put in place because of the pandemic. Did you remember hearing that?
Yeah, absolutely. Yeah, I pointed that out too. Worst pandemic in 100 years.
Is the pandemic over?
No, it's not over.
Are
We're going to have elections in
hospitalizations
November.
as high as they have ever been right now?
Yes.
Gentleman's time's expired.
Thank you, Mr. Speaker and members.
The chair recognizes Mr. Murr to speak against the amendment.
Members, I respectfully oppose this amendment. As you well know, this amendment removes the enacting clause and kills the bill. That's the practical intent of the amendment. You've heard the layout for over an hour. We've talked about the policy for several months. It has been something that's cognizant on all your minds. And so I'll be succinct, because there's a lot of folks talking today, but I simply oppose the amendment.
Mr. Wu, for what purpose?
Mr. Speaker, would the gentleman yield for questions before walking off?
The gentleman yields for questions.
Thank you, Mr. Speaker. Sorry I didn't have a chance to ask questions during the main debate because of the long line. But I have a question. Since the amendment striking the enacting clause opens the entire bill up for questions, I have a question about some of the provisions on page 37.
Page 37, yes, sir.
And as discussed with earlier Representative Wally, this is a provision that creates a new felony-level criminal penalty, correct?
So on page 36 and 37?
I'm just referring to the parts on 37, starting with line 3.
Give me just a moment to flip over there so that you and I are on the same page, literally and figuratively speaking.
And while you're doing that, it's my understanding you practice criminal law, right?
Yes.
Okay. So I want to make sure I'm not going to be talking over your head or anything.
Well, that remains to be seen.
So again, this is the creation of a felony-level criminal penalty, one that did not exist prior to this legislation.
That is correct, and you're referring to the section regarding vote harvesting, just for the clarification of the body, right?
No, this is the page 37.
Oh, unlawful solicitation and distribution of application to vote by mail. Yes.
Thank you. What is a public official? Who is a public official?
Yeah, it's not a defined term.
Am I a public official?
I would believe so.
Is everybody in this body a public official?
Generally speaking, I think the common terminology and the common definition would include an elected official.
Okay.
Yes.
What does it mean when it says, when do I act in official capacity as a state representative?
I assume in the service or exercise of your duties on behalf of the state of Texas.
Because so like, there's not, I don't punch in a clock or anything. There's not a time when I put on a badge that says state official or not state official. I assume that it would be fair to say, like, when I'm doing a campaign event, I'm not acting in official capacity, but let's say I'm having a town hall. Am I in official capacity then?
I don't know that I'm the best person to make that determination.
Well,
but I will point
legislation.
I'm going to point to the top of page 38 when it talks about being engaged in while acting in the official's capacity as a candidate for public office. So you have to tell me, is it town hall a scenario in which you are a candidate or a scenario in which you are currently serving in office?
No, I'm currently serving right now. I'm a currently elected state representative. I'm asking you, under the definition of this bill that you're carrying, if I'm having a town hall, am I acting in official capacity?
I would believe that to be true.
Okay. If I'm walking around town and somebody approaches me and says, hey, you're State Rep Gene Wu, aren't you? And I say, yes, I am. How can I help you? Am I acting in official capacity?
Your fact pattern tells me that that's just simply an identification of your person as serving in office, not necessarily acting. So you got to tell me what the conduct is that you're engaged in besides walking around.
Sure, the person says, hey, can you help me with my problem? And I said, let me hear about it.
Then perhaps you are in your role as a public official.
Okay. But you're not sure?
No, I'm telling you, when you say that they walk around and identify you, you're not necessarily engaged in that. But if they're going to have a conversation about something that relates to the duties of your office or that you're assisting them with constituent services, then I would interpret that to mean that that is engaging as a public official.
So, on line 7, you said solicit the submission of an application. What does the word solicit mean in respects to this particular criminal penalty?
I would assume that it would adopt the plain meaning of the term solicit, which means that you actually take action to I'm going through a mental dictionary here. Solicit means the act or conduct of actually reaching out to another person versus a passive or non-proactive scenario.
So if I am having a state rep town hall and I tell people, hey, don't forget there's a pandemic going on, make sure you apply to vote by mail. That would seem to run in violation of your statute that you're proposing.
Did you provide them an application to vote by mail?
Nope. It says solicit the submission of an application to vote by mail.
Now, I don't believe that your fact pattern fits the terms that are provided in line 7 of page 37 of the document.
You just told me that the term solicit, by your definition, means a person-to-person engagement to request them do something. And I said, I am going out to my constituents during a town hall where I'm acting as state representative, and I'm asking them, telling them, requesting them, soliciting them to turn in an application to vote by mail.
I believe that the act of soliciting involves the presence of the application to vote by mail.
I'm sorry?
I believe that in your fact pattern, the act of soliciting would need to involve the physical presence of the application to vote by mail.
That's not what the word solicit
I
means.
understand, but you're asking me a question and I am giving you a response.
So, if I'm at a town hall and I talk about how we voted on a voting bill and how your right to vote is really important, and I have a stack of vote by mail cards sitting on a table, is that a crime?
I do not believe that is an offense, a criminal offense, no.
And what if I say, hey, there's a stack of vote by mail cards right there on that table. Pick one up right now. Did I just commit a crime?
So I will point out to you that subsection E on lines 25 states that it does not apply if the public official provided general information about voting by mail, the vote by mail process, or the timelines associated with voting or to vote in person.
I've done none of those things. I am very directly telling my constituents, see that pile of vote by mail cards? Pick it up right now, fill it out. Is that a crime?
I do not think that's a crime, no, sir.
What if, instead of having the vote by mail cards on a table, what if I am State Representative Gene Wu having a great discussion with my voters, with my constituents, and I say, here, in my hand is a vote by mail card. I want you to take this card out of my hand and fill it out.
And I have to assume,
as many of us in this body have already done in election after election. Is that a crime now?
I have to assume that you're running for re-election as a candidate for office.
No, sir.
And I would say that it's not a crime.
No, sir.
Under subsection E of this bill, which flows over to the next page.
No, sir. This is a state official, state representative town hall. There is no campaigning here. I've not told anyone that I'm up for re-election. I'm not telling anyone I'm even running for re-election. I'm saying, here is a card out of my hand, go vote.
You didn't ask a question.
Is that a crime under this bill?
And I have said no, that is not a crime, Mr. Wu.
Okay. And earlier, I asked you if you were a criminal defense attorney, and you said yes. And one of the points of criminal law that is very important, and I'm hoping you understand, I assume you understand, is that criminal statutes, more than civil statutes, need specificity. Hope I said that right. It needs to be specific about what is and is not a violation. And throughout this, my questions with you, over these many questions, you're not sure, you have to have some people come tell you or make suggestions. How is the public, how are we as the membership, how are we as state officials under this supposed to interpret this law while we're out? Isn't this, the way it's written, a little bit vague?
No, I don't reach the conclusion that you are asserting.
Gentleman's time's expired. Please excuse Mr. Guillen because of illness on the motion of Mr. Lozano. Is the objection? Chair hears none, so ordered. Mr. Biederman, for what purpose?
Yes, I'd like to have the discussion between Representative Tinderholt and Representative Anchia placed in the journal.
Members, you heard the motion. The objection. Chair hears none, so ordered. The chair recognizes Mr. Lozano to speak against the amendment.
Thank you, Mr. Speaker. Members, I had to get up here and speak about this because of the mention by Representative Anchia of this being about, quote unquote, the big lie, that there were no examples of voter fraud. He brought up Bull O'Connor and fire hoses, which I learned in 7th grade were Democrats. But I want to talk to you about the allegation that there are no examples of voter fraud because I was here in the first special session in a 24-hour committee hearing. I missed my kids' baseball games, my daughter's volleyball games. I heard hundreds of witnesses testify. And if he had been here, if it was that important to him, he would have seen that. But he wasn't. And so one of the things we heard from a witness was that in the 2020 election, there were people that were deceased who somehow applied to vote by mail. Pictures, copies of those ballots, and then some that were forged as well. The way this person was caught was because of a law written in 2003 by Representative Steve Wollens, a Democrat, a brilliant lawyer. Most will say that he was one of the most brilliant lawyers that has ever served in this chamber. In that committee hearing for House Bill 54, there was not one single person that registered against. That bill was the most significant election reform up until this bill. So this is not because of the 2020 election. This has been going on for a long time. This has been reformed by Democrats. And so I need to point out that incredible fact that Steve Wollens has not one single racist bone in his body. That Steve Wollens, in response to his request, and I asked in a press conference in the first special session that our press, that every member of the press be fair, because they wield an incredible amount of influence over our electorate. That their coverage, accurate and in depth, is vital to the integrity of our democracy. I talked about the following articles I'm going to mention that were as a result of Steve Wollens' investigation and what he did. But in Dallas, the Dallas Morning News, a very good, brilliant writer, Gromer Jeffers, wrote in an opinion piece that Texas needs tougher laws to reel in mail-in vote fraud. He quoted Mike Rawlings, former mayor of Dallas, and Eric Johnson, our state rep at the time, who is now mayor of Dallas, as saying, "We ask that you devote additional resources to verify the integrity of each mail-in ballot in Dallas. We look forward to hearing from you soon." Gromer Jeffers said, "A plan is what's needed to root out possible crimes, as well as encourage more voter participation. Lawmakers, election experts, and law enforcement officials, as they did 14 years ago, should develop..."
Will the gentleman yield for a few questions?
Not until I finish, sir.
In 1 moment, sir.
Thank you.
Yes, sir. That we should do what we did 14 years ago to develop new policies to stamp out corruption, even if it costs money and resources. Voter fraud, even with mail-in ballots, does not occur on a large scale. That's nothing that has ever been proven. But in low turnout elections, stealing just a few votes can be the difference between winning and losing. Steve Wollens was quoted as saying, "You have to have a conversation in order to prevent coercion and fraud. Then you tailor-make a new law that deals with abuse." NPR reported in 2015 on their morning edition, July 7th, 2015, NPR, for the press to hear and to look it up. It's easy on Google. In the Rio Grande Valley, some campaign workers are paid to harvest votes. NPR is not Fox News. The title of their show was "In the Rio Grande Valley, Some Campaign Workers Are Paid to Harvest Votes." A new FBI anti-corruption task force is trying to clean up the Rio Grande Valley of Texas. According to the Justice Department in 2013, which was under President Obama, more public officials were convicted for corruption in South Texas than in any other region of the country. One of the practices the task force is looking at is vote stealing. In recent years, losing candidates in local elections began to challenge vote harvesting by politiqueras in the Rio Grande Valley, and they shared their investigations with authorities. After the 2012 election cycle, the Justice Department and the Texas Attorney General's office filed charges. In Dallas, in the Dallas Observer, June 21st, 2018, press, please hear this. Dallas man pleads guilty in 2017 Dallas voter fraud investigation. The DA, Faith Johnson, said this is the first of many milestones in the ongoing investigation into voter fraud in Dallas County. We must protect the process so that all citizens may have confidence in the system. A Dallas County grand jury indicted Hernandez last spring as part of an investigation into voter fraud in Dallas's May 2017 municipal elections. Investigators in the case believed that Hernandez was responsible for at least one tainted ballot turned into the elections department during the District 6 City Council election between Omar Nevarez and Monica Alonso. The ballot was signed Jose Rodriguez, the alias attached to more than 700 ballots requested by a Dallas County judge in the May 6th election. So the way they knew he was tied to 700 ballots is because of Steve Wollen's law that passed unanimously by bipartisan methods in 2003. And so, members, I could tell you about the hearings in 2003 on that bill, which had some pretty incredible quotes by Democrats in committee, which I might hold off. I'm going to hold off on quoting verbatim what the Democrats said in committee, which, in my opinion, they should be joint authors on this bill as a result of their statements. But I've done an incredible amount of research, and I just want to be clear and set the record clear that this is not about 2020. This has been going on, being done since the state and the country had voter rights reforms, election reforms. I will yield for questions, Chairman.
Thank you, Mr. Chairman. I want to start off by just asking you about a statement you made at the beginning where you suggested that I might not care about voting rights.
Well, you weren't here, Chairman. I'm sorry.
But you said if you care about voting rights, you would have been here.
Because you made a lot of misstatements.
Well, hold on.
You would have not made those statements.
Let me ask you about that intent. Let me just finish my question. Do you believe I don't care about voting rights? Since you called into question,
I think you could care a little more, and you should have been here.
Do you think my being in Washington,
Members,
D.C.
please refrain
Do you
from
think
outbursts.
my being in Washington, D.C.
I don't even want to go there.
And meeting with members of the executive branch and legislative branch on voting rights suggested that I cared any more or less about voting rights than you do?
You knew, as everyone in the country knows, that the United States Senate went home and there was going to be nothing accomplished in Washington.
Can you tell me the meetings that I had and how
Did you know the United States Senate went home?
And how you were inferring that somehow suggested I don't care about voting rights?
If you cared more, you would have been here in the special session.
Members, let's please confine our remarks to the amendment.
Well, I would submit to you just that maybe you don't know. Maybe you don't know how much I care about voting rights.
You weren't here.
Now, I want to ask you about the statements you made because you took some isolated instances. And you talked about Steve Wollens. What district does Steve Wollens represent?
It was in Dallas.
In which district?
The number I don't know, sir.
Which part of Dallas?
I have no idea which specific part, but I hope that
Do
some of the voters that they...
Do you know who succeeded Steve Wollens and was endorsed by Steve Wollens?
I didn't look at that part of the
That would be
research.
me. So I succeeded Steve Wollens.
Well, then why aren't you on this bill?
With his support and endorsement. And so,
Seriously.
my
Will you join author this bill?
My point is that the bill you're referring to that Steve passed with bipartisan support, broad bipartisan support, you've given us examples of how that bill worked, have you not?
Exactly.
Okay? And so because that bill is in place and according to you is working, and in fact, I've authored a bipartisan bill with Dr. Oliverson
related to mail-in ballots just 2 sessions, maybe 3 sessions ago.
Are you going to have a disparate impact with your bill?
And it ultimately, unfortunately, it wasn't in place long enough before it was overturned by the majority in this legislature. But let me just ask you, since I can ask you some questions from back here. Is it your contention that the bill that was passed by my predecessor in office, whom I have a very good relationship with, is working?
Definitely, and I will add to that. He did not disenfranchise minority voters with it.
Correct, because it was a bipartisan bill that was done well.
Election integrity reform did not have a disparate impact.
I support.
In fact, early voting went up.
I urged him to deal with that. So
early voting went up.
All the cases that you are discussing, which were prevented or prosecuted under that bill, right?
Absolutely.
Okay. So
and you weren't here, but I'm sure you would have
bill?
voted for it.
How does this bill improve that bill?
Gentleman's time's expired.
Mr. Speaker, I'd like to request an extension of time, please.
The gentleman does not object to extension of time.
Thank you, Mr. Speaker, and thank you, Chairman Gonzalez. How does this bill, can you point to provisions in this bill that improve Steve Wollins' bill?
Absolutely. So Steve Wollins, as you know, I'm sure you know about...
I mean code sections in this bill.
Okay.
Can you point to them?
You said improving on Steve Wollins' bill. And so Steve Wollins...
So what about this bill, though? This bill?
Okay. One of the things that did not exist before Steve Wollins' bill was that he required people to sign the carrier envelope if they assisted someone to vote. Okay,
great.
So this bill, signatures are important, right?
Yes, no question.
Okay, absolutely. Do you agree that we should verify who we are before we vote?
Yes.
What? Let me ask you again.
I don't know why you think, if you've been paying attention at all to my legislative career, you'd know that has always been my position. So
look, I've got 175,000 voters. I can't possibly look at you.
I'm just going to
follow you.
I'm just going to try to come back to the question, which is direct you back to this bill and tell me how it improves upon that bill.
Since you agree that we should verify who we are before we vote, this bill applies the same standard from in-person voting to mail-in voting.
Can you point me to that section of the bill?
It's, I'll just tell you, that section is the one that says that if you vote by mail, you have to put your social or your driver's license number on that. Because as you can see, is what I mentioned earlier.
And what happens if...
Let me finish my answer,
But what
please.
happens
as
if
you can
you
see,
do not...
whenever you...
What happens?
As I mentioned earlier,
I'm familiar with that code section, but what happens if
you would have known,
in the
there
case
are ballots
where you
that
have
are just in the 2020 election that have been forged by signatures that have been. How does a dead person apply for? How does a dead person apply to vote by mail?
Was that prosecuted?
Somebody forged their signature, right?
Was that prosecuted?
Obviously. And so these are the things that this bill addresses.
Okay. So you were in the section that you did not specifically name, but you alluded to. I want to ask you about that. If a person registers with their Social Security number, but then when asked to verify on their ballot application that they put down their voter number or their driver's license, and under this bill, that ballot would be thrown out, correct? Or could be challenged?
Yes.
Okay. And so what is the, do you think that that's a problem?
Okay, so right now
No. Do you think that's a problem that if someone did not remember when they registered to vote whether they used their driver's license or Social Security number, and they put the other number down on the carrier envelope, that would be thrown out?
Either number should work, in my opinion.
What's that?
Either number should work.
Is the bill written that way today?
Honestly, I think there might be amendments
but
that address
is it written that way today?
I support an amendment that fixes that. But as I've seen it now, it does not.
Okay, so it does not. And I think that's the correct analysis. So the code section that you actually suggested was an improvement on the prior bill, which I wholeheartedly accept.
Hold on. You do think it's an improvement?
Please, JM. Please. Chairman Gonzalez.
It's Lozano.
Oh, sorry, Lozano.
It's okay. We all look the same.
Certainly do. So, Chairman Lozano, and I apologize for calling you Chairman Gonzalez.
It's okay. It's all right.
I apologize.
I forgive you.
Thank you. So, Chairman Lozano, was there an improvement? Do you consider that code section that you alluded to an improvement on the 2003 bill as currently written, when people's votes can be thrown out?
You just said it did, and I agree with you. It does improve on that.
Okay, so you believe that the current code section that would allow for a person's mail-in ballot to be thrown out improves on the 2003 bill? Chairman Lozano, sorry.
You just said it improves on it. I agree with you, it does.
I asked. So you think the fact that ballots can now be challenged and thrown out because of an incorrect number is a good thing?
Look, we need to verify that people are who they are before they vote.
Stipulated. But do you believe that this part of the bill that you pointed to as an improvement, where hundreds of thousands of Texans who may not have remembered when they registered, if they registered with their driver's license number and Social Security, and they put the wrong number down, even if they are who they say they are, that is an improvement in the bill?
Yes. And
okay.
the thing, yeah.
So I will take you at your word that
we're going to fix that part,
that
but if they need to verify who they are with either their driver's license number or the Social Security number, just like you do when you vote in person, you have to verify your identity.
And if you use the wrong number, you think it's okay for that ballot to be thrown out?
As long as they use a number on their ballot. Now, we need to clean that up, in my opinion, in an amendment.
I think you have well stated your intent. Thank you.
Thank you.
Mr. Speaker. Mrs. Schofield, for what purpose?
Will the gentleman yield?
The gentleman yield for question. Gentleman yields.
Mr. Lozano, I'd like to build on your conversation with Mr. Anchia. First of all, let's start at the end. Am I not correct that in this bill, a voter whose mail ballot is rejected would be able to cure under the bill? So should somebody write their Social Security number down wrong, the county could then contact them, and then they have an opportunity to cure, and they would still vote.
That's in the bill, absolutely.
But if someone's out there trying to cheat hundreds of mail ballots, the odds that they're going to get correct Social Security or driver's licenses to put those in and counter the votes of hundreds of real Texans is very unlikely. Is that not true?
Absolutely.
I appreciate that. First, it was said earlier, and I think somebody slipped it in, that drive-through voting is currently legal. Are you aware that the only curbside voting that is legal in Texas is for disabled voters who prefer to use that to get to the polls?
That's correct.
Are you aware from the testimony during the regular session in the Elections Committee that the drive-through voting that was instituted in Harris County was used repeatedly to when they would hand the tablet to the voter would then turn and hand it to the activist that brought them, and they would vote the ballot?
I had not heard of that.
And so I just want to make very sure, because a lot of what's being said today is legitimate debate, a lot is political theater, and some of it is for the judges. I want to draw the judges' attention to the testimony that there was a repeated pattern of getting the tablet from the rightful voter and having someone else vote it, and that is the reason why we oppose having drive-through voting, because it is a recipe for fraud. Is that your understanding?
Yes.
Secondly, we heard, I'm trying to remember if you were at the hearing, but do you recall the testimony from the regular session about the persistent misuse of provisions in Texas election law that are designed to protect the disabled, and people were using those for vote harvesting? Did you hear any of that?
Yes.
Do you remember the testimony that a woman went to vote, she gets glommed onto by somebody who's been doing this all day in the parking lot, takes her in to vote, takes her into the machine, casts a vote, and then, if you remember the testimony, she said, "When do I get to vote?" And the answer is, "You just did." And these ballot harvesters were stealing people's votes all day, every day during early voting and on election day. Do you remember that testimony?
Yes, I do.
Do you also remember the testimony from Harris County that when people say, well, what's wrong with just sending out lots of mail ballot applications? Well, first of all, are you aware that there are only 3 categories of people that can vote by mail in Texas? People who are over 65, people who are disabled, and people who are going to be out of state when on election day. You aware of that?
Yes.
And are you aware that in Harris County, they wanted to just mail out applications to everybody, including people who could not legally vote and would be enticed to vote illegally if they cast those ballots? Do you recall that?
Yes.
Do you also recall that because of COVID, so many people returned applications and then decided they wanted to vote, and under our law, had to bring their ballot back? And those ballots were not being canceled, were being put in boxes, and never showed up on the logs, and that there were boxes and boxes and boxes of blank mail ballots that could be voted by anybody that were not accounted for. Do you remember that?
Yes, I do.
Is that a reason why we would not want willy-nilly mailing of applications and mail ballots to people who don't qualify for them and who did not ask for them?
Absolutely.
And with that, I see the speaker getting up, so I think I'm about to get gavelled. Thank you, Mr. Lozano. I appreciate your...
Thank you.
Appreciate your...
Gentleman's time's expired.
Next, Mr. Speaker.
Mr. Busey, for what purpose?
Ask to extend the time.
Members, this requires unanimous consent. Is there objection to the extension of the time? There is objection, Mr. Busey. Does any member wish to speak for, against, or on the amendment? Hearing none, the chair recognizes Mr. Anchia to close on the amendment.
Thank you, Mr. Speaker and members. And I'm grateful for the banter and repartee with Chairman Lozano. I apologize for misstating your name. It really was an oversight on my part, probably a senior moment. What I do take issue with is really the policy, where we have a bill that's been working since 2003 that I think Chairman Lozano made the case for. It was a bipartisan bill. There was no testimony to suggest that there was going to be a discriminatory impact in that bill. And guess what? It leads to prosecutions in those very small cases. As I said at the beginning, I think it was mischaracterized later. Those very small cases, those rounding error of a rounding error where we do find fraud. And I said that at the outset of my comments. But it's not material based on the legal votes that are cast. And so it was his position that it is a good policy result for someone who has identified themselves with 2 different numbers. Their driver's license number when they first registered, and I don't know how many of you, do y'all remember if you used your driver's license number or your social security number when you first registered years and years ago? I would submit to you that many of us don't. So that when you offered up your mail-in ballot and marked the carry envelope with maybe the second identifying number that you didn't use initially, that your ballot could be challenged and thrown out, even with a cure, even with cure. Even if that exists, why are we adopting a policy that would de facto allow that ballot to be challenged? I don't want my ballot to be challenged because I used my driver's license in one occasion and then I properly identified myself with the social security number. I've identified myself in both instances. Why is the assumption that somebody, your neighbor, somebody you don't know, can say your vote does not count, even though you correctly identified yourself twice with 2 discrete identifying numbers? Somebody can walk up to you and say, nope, your ballot's thrown out. Why is that the assumption of this bill? The assumption should be just the opposite, that is your ballot is a valid ballot. It is a correct identifying number. And you have to prove that your ballot should not count. This bill flips it on its head. And I think that's unlike Chairman Lozano, who suggested that it was a good result and an improvement on the bill. I think it is not. I think that provision itself is rife for abuse by people who will affirmatively challenge senior citizens, the disabled, who just made the grave error of not remembering whether they used their social security number or their driver's license when they registered to vote maybe half a century ago. And that's just bad policy. That's what I was trying to point out. Yet Chairman Lozano points to that provision as an improvement? I think I just have a fundamental policy disagreement with him. I don't think that's an improvement. And in fact, when this has been analyzed by independent media, they pointed out that this could be hundreds of thousands or even millions of ballots that would be challengeable. And why is that the presumption? When we know the incidence is a rounding error of a rounding error, where the author himself said, I'm not advised. And where we know that the existing bill, I think as was eloquently discussed by Chairman Lozano, is working. Why do we want to change that standard? I think it's bad policy. And I'm proud to say it up here. And I was happy to have that policy discussion, because if that is the one way that there's an improvement on the law that had broad bipartisan support that was already in place that is causing these prosecutions, no, I don't see that as an improvement at all. So with that, if Chairman Busey has a...
Just for a quick question.
If Representative Tallarico has a question, I'm happy to answer it.
Does definitely not Mr. Tallarico
Oh, sorry.
have a question?
Representative Busey, I'm bad with names today.
We all look the same.
You all look the same.
Mr. Chairman, just a quick question. We just heard a dialogue between two of our colleagues back and forth talking about testimony in committee that they acknowledged they had heard. Has any of that dialogue that you know of around drive-through voting turned into any convictions, or is this just sharing tinfoil hat accusations on the floor of the House?
Look, people say a lot. I've sat through, because I really care about voting rights, even when I have been on committees, I've sat through, I served on the Elections Committee for 6 years, and people would come up with the most outlandish accusations that never resulted in any further actions. And the Secretary of State has data on this where they get concerns about irregularities. They have to filter through a lot of it, and if they find something actionable, they turn it over to the Attorney General. And it's usually just a tiny little sliver of a percentage, and more often than not, it is anecdote, unsupported by facts, accusations, unsupported by evidence. So you hear that over and over and over again. And I am unaware that any of the information that was offered up by, from the back mic was offered up with any facts at all.
I think it was not, and I would have loved to ask for any proof of it, but I guess our time was expired. Thank you, sir.
Proof is pretty thin, I would say. Proof is pretty thin. So members, we've been on this amendment for a long time. I would say if you think, as Representative Lozano does, that the 2003 bill is working, if you think that prosecutions in those very limited cases, those rounding error of a rounding error cases, is working, and you think it's bad policy for us to be throwing out ballots just because somebody didn't remember whether they put down their Social Security number or their driver's license when they first registered decades ago, then please support this amendment. And thank you for the use of the hall.
The question occurs on adoption of the amendment. A record of vote has been requested by Mr. Anchia. The clerk will ring the bell. All members voting. All members voting. There being 40 ayes, 79 nays, the amendment fails to adopt. Following amendment, clerk read the amendment.
Amendment by Murr.
The chair recognizes Mr. Murr to explain the amendment.
Mr. Speaker, members, thank you for the opportunity. This is a perfecting amendment that I actually filed yesterday evening, and I also sent out a memorandum that I typed up to try to give you some in-depth explanation. Happily to to go through it really quickly. I know that there may be some questions on it. There are multiple parts to it, so I'm going to refer to them by each identified part. On page 1, it replaces the term strictly construe with the word interpret. Number 2, it actually reduces the amount of information that must be supplied by the person registering to vote. Specifically, it excludes information relating to their name, date of birth, and residence address. In July and August. Number 16 accompanies that same revision. Number 17 provides conforming changes to align with the SB1 engrossed version sections 4.08 and 4.09 to include a number from an election identification certificate to forms of identification that may be submitted by a voter when applying for an early voting ballot application. Those same changes are reflected in number 18 of this amendment. Number 19 adds a new section to Article 5, providing that an online tool used in Section 86.015 of the Election Code must allow a voter to add or correct the identification number that they have that they might be using to vote by mail. Number 20 references Section 5.09, which includes the opportunity to correct a defect and clarifies that a voter can correct the identification number. Conforming changes are also reflected in numbers 21 and 22. Number 23 applies to section 5.09 to make notices to cure by mail mandatory if the Signature Verification Committee determines that it would be possible for a voter to correct the defect and return it in time, or if the committee determines that it would not be possible for the voter to correct and return it, the committee may, that's permissive, notify the voter via telephone or email to inform the voter that he or she may request to have the application to vote by mail canceled or come to the early voting clerk's office in person to correct the defect. There are conforming changes with that change in sections 24 and 25. Number 26 corrects mismatching numbers issue that we recently talked about, and we heard that this remedy with this proper language should address concerns raised during the committee hearing. Those changes are also reflected in numbers 27. Number 28 affects section 5.10 and removes a requirement that the early voting ballot board request from DPS any signature of the voter that DPS also has on file and allows the board to compare the signatures of the voter that the voter submits with any known signature of the voter. Conforming changes are also present as numbers 29 and 30. Numbers 31 also reflects similar language to clarify that a voter can correct the identification number with the early voting ballot board. And you see conforming changes with numbers 32 and 33. Number 34 makes notice to cure by mail mandatory, just as you heard earlier when I referenced the Signature Verification Committee. This one should apply to the early voting ballot board, and so I will have an amendment to the amendment momentarily that would correct that drafting error. Conforming changes exist as numbers 35 and 36. Number 37 applies to section 6.03 and removes certain language regarding physical disability from the oath required of those providing assistance to voters. And I understand that is a change that was requested by disability advocates. Number 38 applies to Article 6, an amendment that would add a requirement that the Secretary of State conduct a study regarding the implementation of education programs to help voters with disabilities understand how to use voting systems used in this state. And you will find that language to be in the SB1 engrossed version as section 5.07 offered by Senator Zaffirini. Number 39 of our amendment replaces the definitions of vote harvesting with Senate versions of the definitions of benefit and vote harvesting services. Number 40 alters the circumstances to which the vote harvesting section does not apply. Number 41 clarifies that the provision applies to both an elected official and an election official, which we were visiting about earlier when we were laying out the bill. Number 42 adds a knowing requirement to the offense of perjury in connection with certain election procedures. Number 43 is a recommendation of the drafters to add the effective date for the Code of Criminal Procedure to be September 1, 2021. Number 44 repeals a section of the code that was referenced in the Senate Bill 1 engrossed version that arrived from the Senate. That has to do with the partial count of electronic voting system ballots by general custodians. It states that the Secretary of State at any time may waive or reinstate the requirements of this section for a particular political subdivision. And with a brief explanation of those, I'm happy to answer any questions.
Mr. Turner, for what purpose?
Would the gentleman yield for some questions?
Happy to yield.
The gentleman yields for questions.
Thank you. Representative Murr, my question starts on page 5 of your amendment, related, going to line 7, and that section there that follows line 7 through line 16 on page 5, related to the Signature Verification Committee. And on line 10, it says the committee may notify the voter of the defect by telephone or email and inform the voter that the voter may request to have the voter's application to vote by mail canceled in the manner described by section 84.032, or come to the early voting clerk's office in person not later than the 6th day after election day to correct the defect. So my question is, why is the committee not required to notify the voter, and the language simply is permissive and says the committee may notify the voter?
Yes, sir. So, Mr. Turner, if you will, in your review of SB 1 as it's on the floor of the House, and you compare it to SB 1, the engrossed version that left the Senate, you will see that one version of the bill, the House version, contained mandatory language, and the Senate version contained permissive language. And there were concerns that were raised by stakeholders and other interested parties that said, if the language is permissive across the board, will there be a uniform and consistent application of this process county by county, or essentially committee by committee, to ensure that there's an opportunity to cure? And so consequently, the language you're looking at here, I'll call it a hybrid, which creates a mandatory requirement of notice if it's determined that there is a reasonable opportunity to cure it, with a permissive opportunity so that it's in the code that if they think there's not enough time to mail it to them and for it to be returned in time to be counted for the election, that the committee could contact them and let them know that, and that gives that voter the opportunity to come in person and make the correction or take other action to cancel their application to vote by mail. And so the goal here is to see that there's consistency across the board with that, and at the same time, we wanted to be deferential to the ability to contact folks and let them know of a defect they could cure.
Okay, so I think your explanation leads exactly to my concern, is that the language leads to inconsistency, or potential inconsistency. If the committee determines it would not be possible for the voter to correct the defect and return the carry envelope before the time the polls are required to close on Election Day, I'm quoting from the bill there, the committee may notify the voter, which means the committee may also not notify the voter. So what happens under this language if this becomes law? Could you see a scenario where in Tarrant County, where I live, that the committee may decide not to notify voters in that situation, but a few miles next door in Dallas County, the committee does decide to notify the voter? Is that possible under this language of this bill?
And I want to answer your question, and I'm not going to deflect, but I'm also going to state we have a mandatory requirement if it's determined that they have sufficient time to correct it by mail. But absent us speaking to it in the legislation for the ability to contact them by other means, specifically by telephone or email, one would interpret the election code to say the committee can't reach out to those individual voters to say, you've run out of time for us to mail it to you, you correct it, and mail it back. And instead, we want to make sure your vote gets counted. There's a defect, you can come in and correct it in person, or you could cancel your application to vote by mail and come in and vote in person. And so here, we're actually allowing the opportunity, but with permission, for them to make that contact with that voter, especially whenever time is of the essence. So right. It's permissive for that purpose, because the second part, we heard some witness testimony, and their concerns were the ability and manpower, if it was mandatory when you ran out of time, to try to hunt down everyone with a telephone number or an email and let them know.
So since it's permissive and they have that discretion, isn't that inevitably going to lead to situations where two voters could be in an identical situation where they send in a ballot with a defect, but in one county, the voter is afforded the courtesy of being notified of the defect by phone or email and is given the opportunity to correct it because they've been given knowledge of the defect. But in another county, the voter in the exact same situation is not giving notice of the defect. They think their vote counts or will count, and in fact, their vote will not count. Isn't that exact scenario possible under the plain language of this amendment?
And you have to view that in the light of these counties depend upon election workers, many of which are volunteers, and it has to do with available manpower, either hired or volunteer, in order to affect the ability of this to happen. So if you're looking at notice provisions in a scenario such as this, you want to make it mandatory when you know there's time for them to do it by mail, because the intent was always to vote by mail. That was always the voter's intent when they submitted an application to vote by mail. Giving them a mandatory provision to correct it by mail when there's time to do so is appropriate. And when they're out of time, giving the committee permission to contact them by other means and let them know there's a defect and they can either cancel their application or come in person and correct it, that actually speaks to improved opportunities for that voter to make sure their vote gets cast.
But they're uneven and unequal improved opportunities. If one county does it and another county doesn't do it, then voters are being treated unequally. And they're not being given the same access to the freedom to vote if one voter has knowledge of a defect of their ballot in their ballot and another voter does not have that same knowledge.
But they are
you would
being
agree
treated,
that's unequal, right?
Sorry. They are being treated equally if there's actually time to cure it by mail.
But if there's not time,
and so
if they're in this window where there's not time,
there's not time. So
treated.
right now under the law, there's not time. There's not necessarily a mechanism for them with permission to contact the voter and let them know of a defect. And so if you don't look to the code for that authority to make contact, then is it really appropriate for them to contact them now? So this is actually a step in the right direction.
Well, for voters who are fortunate enough to be in a county where a signature verification committee says we're going to take this step, but if you're in a county where the signature verification says, well, we just don't have time or we're too busy or whatever, then that voter's simply out of luck. So let me ask you this, though. With respect to the same county, what is there anything in the language that says, okay, if a ballot has a defect and the signature verification says, well, we may notify those voters, we're going to go ahead and notify them via mail or email, email or telephone, but they look at another ballot and say, you know what, we don't think we need to notify this voter. Is there anything that guards against the signature verification committee from picking and choosing which voters it may notify of the defect?
And again, that's going to depend on the time circumstances, because in every scenario, as you tick closer to the deadlines that apply to your election, essentially it doesn't matter what jurisdiction or that you're in, there is going to be a point where they are unable to ensure contact with that voter, and that voter have an opportunity to cure.
So in one case, let's just use Tarrant County. We'll pick on my county as an example. In Tarrant County, the signature verification committee could have a pile of ballots that they've identified a defect in. And they say, well, we have the authority now under statute that we may notify the voters of these defects. And we're going to notify a few of these voters, and then if we get busy or run out of time, we don't have any requirement to notify the rest of those voters in the same manner. Is that right?
And there is no requirement for them to notify those voters under current law.
So under this language, some voters could receive the extra benefit of a notification of a defect in their ballot and be afforded the opportunity to correct the defect to ensure that their vote is counted, and other voters will simply not have that opportunity because the signature verification committee arbitrarily decides we are not going to give them that opportunity. Is that right?
That is based on time and the availability of manpower to make these contacts with voters.
So it is completely within the discretion of a signature verification committee if voters get notified, and if so, what voters get notified?
Only after the signature verification committee has determined that there is not enough time to mail back the ballot for them to correct it and return it so it can be counted.
How are signature verification committees selected or appointed? Are they partisan officials?
Just to go back to the definition of a signature verification committee, it means a group that meets prior to Election Day to compare the signatures on applications for ballot by mail to the corresponding carrier envelopes. And my notes reference me to section 87.027 of the Election Code.
Do political parties have a role in nominating or selecting who is on a signature verification committee?
I would need to go and read that specific statute in order to give you a proper answer. And I just don't have that in front of me at the moment.
Okay. Representative, these are partisan officials who are being given power to pick and choose which voters they want to notify of a defect in their ballot and which voters they do not want to notify of a defect in their ballot. So I think this is a huge problem in the amendment that will lead to unequal treatment of voters, both within a county and across multiple counties. Let me ask you a question quickly on a different section. On page 7, you add language about the Secretary of State shall conduct a study regarding the implementation of educational programs, including the production as it relates to voters with disabilities. Did you consider also adding in language that the Secretary of State shall conduct a study regarding the racial impact of this bill?
No, sir. I looked directly to section 5.07 of the Senate Bill 1 as engrossed out of the Senate for that language. And I know there was a discussion, and I believe that Senator Zaffarini offered this specific language. So
thank you.
I wanted to be able to have everyone consider it.
Mr. Turner, for what purpose?
Mr. Speaker, will the gentleman yield for questions?
The gentleman yield for questions?
I will yield for questions,
Gentleman
yes.
yields for questions.
Thank you, Representative Murr. As we look at your amendment here, it seems that a pretty significant part of it relates to the issue of requiring voters who vote by mail to provide the numerical identification, either driver's license number, last 4 digits of social security number, or election certification number when they send in their ballot or when they apply for a ballot by mail, correct?
Yes.
And just for some background here, Texas, I understand, is one of a fairly small minority of states that actually requires you to have some kind of excuse in order to vote by mail in the first place. Is that your understanding also?
Yes, and in fact, earlier today I detailed out what the list of eligible requirements were in order to vote by mail.
So we as a state are in the minority with respect to that. Now, how many states, to your knowledge, require that if you have a mail-in ballot or vote by mail that you have to provide some kind of identification number when you do it?
I am not advised of that information.
Well, to the best of my understanding and research, it's 2 other states. So Texas would only be the 3rd. You're not aware of anything different from that?
I'm not advised, so I would defer to you on the content of that.
And my understanding is at least one of those states, of those other 2, would still allow the acceptance of the ballot despite having the number be mistakenly written, as long as the signatures do match. So the amendment language that you have here, though, would not allow that, correct? If there is a number that is a mismatch, the ballot is going to be rejected, subject to the cure provisions,
Well,
correct?
that's what I was going to get to, is we've gone to great lengths to provide opportunities to cure, and those opportunities to cure would include making errors or mistakes with the numbers themselves. And if I will point out, that was actually omitted in SB 1's language that we brought to the floor, and these changes here would expand that to include errors with the numbers themselves. And we saw that in the engrossed version out of the Senate.
And I would agree, from my perspective, Representative Murr, that is progress to add those cure provisions. But would you also agree with me that there still will be cases in which a person receives notice of this mistake too late to cure it?
I think that's always going to be the case, because time is the enemy whenever you are conducting an application to vote by mail and actually tendering your ballot to vote by mail. It still needs to arrive on or before a certain date in order to be counted for the election.
So if someone either made a mistake and recorded a number incorrectly, or they just weren't aware of this new requirement and inadvertently didn't write the number on the carrier envelope, and they sort of voted maybe the same time they generally do, it's possible that they're going to be notified too late of that mistake, and they will just have missed voting potentially in that election by having their ballot rejected. That's correct, isn't it?
And it's possible that someone didn't put postage on the envelope, or put the wrong address, or forgot to check the mail for several days. So yes, there's a lot of moving parts to the process of voting by mail, yes.
Right. And we've added a significant new one here by becoming one of 3 states potentially to require this numerical identification. Let me ask you another question. It's my understanding that there are about 1.9 million Texas voters that currently only have one kind of number in their voter file, either the last 4 digits of their social security number or their driver's license number, but not both. You agree with that?
I do not disagree with your numbers.
And so if someone in that category votes by mail and they happen to put the different kind of number down on their carrier envelope or their application to vote by mail, so let's say they just have a social security number on file, but they instead write their driver's license number on their ballot envelope, their ballot will be rejected for that reason under this language, correct?
Yes, but I would point out that at the bottom of page 2 in number 16 of this amendment, there is language where, assuming that there is an appropriate amount of time, they would receive notice from the clerk of the issue, and they could go and be able to correct that and proceed to be able to vote by mail.
And that's the cure provision we were just talking about a moment ago, if there's time.
If there's time, and time is always the enemy whenever you vote by mail.
It would be possible, I assume, to put language in this bill saying that if you're one of those 1.9 million voters who only has one number on file, and you correctly put a different kind of number, your driver's license number, if your social security number is the one on file, that your vote could still be counted as long as your signatures match and the other requirements are met. We could have that language here, and that would avoid not having ballots counted, wouldn't it?
Well, respectfully, I would point out to the fact that over on page 5, for example, in numbers 26 and 27, those are examples of applying the Senate bill engrossed version of its language to the bill before the House today. It actually broadens that to remedy the scenario you speak of, where there was one number on file and a different number was used in the application to vote by mail. This language is broader, and according to resource witnesses with the Secretary of State's office, this language would certainly allow the clerks to be able to identify the fact that one number was used to register to vote a long time ago, but the person used a different number, not that number, in order to have their application to vote by mail, and yet it still identifies the same voter that's been identified with the numbers.
Well, now my understanding of that was that would only be true for a voter that had both numbers in their voter file. So
yes, and that's why we were talking about the provisions at the bottom of page 2, which if there isn't enough information in that database, it's a very obvious way for a clerk to give notice that there is a lack of information and give that voter a chance to remedy it by providing that information through the online portal.
So we agree, in other words, that for the 1.9 million voters in this category that only have one number on file, if they put the wrong kind of number, they may get notified that they have an opportunity to cure it, but if they don't get that notice, or if they don't get it in time, their ballot will not count.
Well,
that's
and I believe,
correct, isn't it?
I'm going to go back and explain that that's not a ballot. That's simply an application to vote by mail. So they haven't got to the point of receiving a ballot. It's just receiving the application to vote by mail, didn't have the information. The clerk says, here, I need you to go, you need to understand what the defect is. Here's an opportunity to cure by using the online tool. My point being, typically when you make an application to vote by mail, you're doing that well in advance of the time period in which you're going to vote by mail. So generally speaking, a voter should have an opportunity to be able to cure this. And I would point out that once they do cure it by going through the online tool and supplying that information, that going forward, those numbers would always be accessible and they would never experience that problem again. So going back to the original number that you cited, for example, I believe it was 1.9 million, through this process of this language, that would dwindle substantially over time to the point that it would be negligible, I would hope.
Now, negligible in the context of 1.9 million might still be, what, 10,000, 15, 20,000 people,
that's
something
more
like
than
that.
live in my home county, yes, sir.
Yes, that's a lot of voters. I mean, we
It
don't
is.
know what number of voters may not have the opportunity to make this cure and not have their ballot counted or their application to vote by mail accepted. Do you have any evidence, or has there been any testimony or anything in the record showing how many Texas voters will not have their mail-in ballot accepted because they put the wrong kind of number, not the wrong number, but the wrong kind of number on their either application to vote by mail or their mail ballot?
No, I have not seen any evidence one way or another on that information.
If I can, I want to cover one other area very quickly, Representative Murr, and that is related to the provisions on vote harvesting that are in your amendment before us here. And I'm specifically on page 8 of the perfecting amendment. And if we look here at lines 8 to 11, there has been a new definition provided of vote harvesting services. And I'll let you get that in front of you because I want to ask a couple of questions about that.
I have it in front of me, yes, sir.
Now, I'll say, Representative Murr, this is an area of the bill that I have very significant concerns about in introducing new criminal penalties in ways that I'm concerned could have unintended consequences. But I do want to at least ask you about a scenario to see if you can help clarify in a particular case whether you think conduct would be a criminal offense under this language.
Absolutely.
So if we look at that definition of vote harvesting services, and then we also look at lines 14 and 15, there's an addition there to say that the criminal offense will not apply to interactions that do not directly involve an official ballot or ballot by mail, correct?
That is correct, yes.
Okay. The scenario I want to ask you about is, let's say you have a campaign worker who is paid, so they're compensated, so they do fall under that provision of the bill, and they go knock on somebody's door for a candidate, as we all have paid campaign workers, I think, who often do door knocking, and let's say they encounter a voter who is a voter by mail, and they have the mail ballot nearby when a door knocker comes to their door and knocks on their door and asks them to vote for a candidate. As I read this language, I had some initial concern that that might fall within this definition, this criminal offense definition of vote harvesting services. Can you tell me whether you agree or disagree with that?
I would disagree with that, and just to remind our colleagues, you're talking about a scenario of not a candidate and not a non-paid volunteer, but specifically a compensated or employed campaign worker. I would point to the provisions of the bill under section 7.04, subsection B, when it talks about the actual offense that you speak of for vote harvesting. A person commits an offense if the person, directly or through a third party, knowingly provides or offers to provide vote harvesting services. And my point would be, given the fact scenario that you just played out, I believe that would be incidental contact. That would not be a scenario in which services as defined are being provided. And I do not think that is a criminal offense, and I do not believe that that is the intent of the vote harvesting provision.
So you today, as this sponsor of Senate Bill 1 here on the House floor, would not say that a campaign worker who speaks to a voter at the door and the ballot is somewhere nearby, a mail-in ballot is somewhere nearby, as long as they don't collect that ballot and take it and return it, you don't interpret them as falling within this language. Is that correct?
That is correct. That would be incidental contact as long as they don't take and collect the ballot, which would then bring them under either subsection C, paragraph C or paragraph D, which talks about actual physical collection of the ballots. So if it's simply incidental contact around the ballot, a paid campaign worker would not be subject to the provisions of the vote harvesting section of this bill.
Thank you.
The following amendment to the amendment, the clerk will read the amendment.
Amendment to the amendment by Murr.
Chair recognizes Mr. Murr to explain the amendment.
Members, this is simply a correction. I spoke about it earlier, that the term Signature Verification Committee was inappropriately used twice, and it replaces it in the correct section with Early Voting Ballot Board. So I would move adoption.
Mr. Murr sends up an amendment. The amendment is acceptable to the author. Is there objection to the adoption of the amendment to the amendment? The chair hears none, and the amendment is adopted. The following amendment to the amendment, the clerk will read the amendment.
Amendment to the amendment by Cain.
The chair recognizes Mr. Cain to explain the amendment.
Members, in reading Representative Murr's amendment, you may have noticed that we're adding the word "or election official" to the code 5 times. And the code does not currently have an existing definition of an election official under section 1.005. So after consulting with the Secretary of State's office to properly define that, this amendment would add a definition so that everybody's aware of what election official means. I believe this amendment's acceptable to the author.
Mr. Cain sends up an amendment.
Move adoption.
The amendment is acceptable to the author. Is there objection to the adoption of the amendment to the amendment? The chair hears none, and the amendment is adopted. Mr. Turner, for what purpose?
Mr. Speaker, I would like to make a motion that all of the dialogue today on Senate Bill 1 and the amendments be reduced to writing and placed in the House Journal.
Members, you've heard the motion. Is there objection? The chair hears none. Motion is adopted. Is Ms. Cole on the floor of the House? Is Ms. Cole on the floor of the House? The following amendment to the amendment, the clerk will read the amendment.
Amendment to the amendment by Cole.
Chair recognizes Ms. Cole to explain the amendment.
Thank you, Mr. Speaker. Members, legislative intent matters. When our local officials, election officers, and courts are sifting through this law and figuring out how to enact it, they will be forced to interpret our legislative intent. We have heard in this chamber how important it is that every eligible voter be allowed to vote and every legal cast vote is counted. To that end, I am proposing a simple amendment inserting language to our existing labor intent by maximizing the language expressly on our interest to support opportunities for voting, declaring voter access in favor of voting, and promoting voter participation. I can state that my beliefs very simply: let Texans skate. My complete beliefs that we should expand voting. Let Texas members vote.
The chair recognizes Mr. Murr to speak against the amendment.
Members, while I certainly respect Representative Cole's points of view and her interest in speaking to make changes to the bill, I respectfully oppose the amendment to the amendment.
Chair recognizes Ms. Cole to close on the amendment.
Members, let voters vote.
Question occurs on adoption of the amendment to the amendment. A record vote has been requested by Mr. Cook. A record vote is granted. The clerk will ring the bell. Show Mr. Hunter voting nay. Show Mr. Murr voting nay. Show Mr. Cook voting nay. Show Ms. Cole voting aye. Show Ms. Rose voting aye. Show Mr. Buckley voting nay. Show Ms. Click voting nay. Show Mr. Smith voting nay. Show Mr. Rogers voting nay. Have all voted? There being 36 ayes, 80 nays, the amendment fails. The following amendment to the amendment, the clerk will read the amendment.
Amendment to the amendment by Cook.
The chair recognizes Mr. Cook to explain the amendment.
Thank you, Mr. Speaker. Members, I believe that Chairman Murr hit the correct language in his original bill, and therefore I'm asking that the language on page 2, line 22 be struck, lines 2 and 3 be struck.
Mr. Cook sends up an amendment. The amendment is acceptable to the author. Is there objection to the adoption of the amendment to the amendment? The chair hears none, and the amendment is adopted. The following amendment to the amendment, the clerk will read the amendment.
Amendment to the amendment by Thompson of Harris.
Chair recognizes Ms. Thompson of Harris to explain the amendment.
Mr. Speaker, members, this is a reduction in penalties, and the purpose of this is most persons who work these polls are people who are just normally retired teachers and folks like that, and they're making a very small amount of money. It seemed like to me that for the mistakes of things that they are mistakes and errors that they may make, we are going to be exacting a very high penalty for that. And I just think that if we have people coming doing hourly work to run our elections and make sure that they are safe and secure, that they shouldn't be penalized to the nth degree. So I am moving to lower the penalty from a Class A to a Class C, and I move adoption.
Ms. Howard, for
I know
purpose.
that, Mr. Chairman, I believe the committee, you are accepting this one, aren't you?
Ms. Howard, for what purpose?
Would the gentlelady yield?
Would the lady yield
I
for
do.
questions?
I
She
do.
yields for questions.
Thank you, Ms. Thompson. So do you know, is it currently somewhat difficult to get enough election volunteers as it is to work the hours, to be there, the low pay, if they get any pay at all, or they're volunteers? As you said, it's a lot of retired people who are doing this. Is that not correct?
Yes, yes.
So do you think this would discourage some from actually doing this work?
Absolutely, and then what you're paying them for and what you want to charge them with is far going to exceed for them to be able to have money to even defend themselves against these errors that they may make.
So this might make it more difficult to staff polling sites, which might, again, make it more difficult to have opportunities for Texans to vote. Is that correct?
Absolutely.
Thank you.
I move passage.
The chair recognizes Mr. Murr to speak in opposition to the amendment.
Mr. Speaker, members, while I greatly respect Ms. Thompson and her points of view, especially having to do with criminal penalties, this portion of the amendment is important. We heard numerous witnesses testify about it, and while I perceive it to be a drafting error on my part, I'll point out that it has to do with the penalty for an election officer who intentionally or knowingly refuses to accept a poll watcher for service when required to do so. And notably, our witnesses pointed out that current law, which is similar under section 33.061, has to do with obstructing a poll watcher, is also a Class A misdemeanor. And so we're not doing anything that is outside the box. In fact, we are creating a standard that appears to be consistent across the board with regard to criminal penalties in the election code. And so, respectfully, I oppose the amendment to the amendment.
The chair recognizes Ms. Thompson to close on the amendment.
And I respectfully disagree with my colleague. You know, we have spent the last two sessions lowering penalties on various offenses within this state. And those offenses were far more serious in the eyes of many people than what this penalty of poll watchers in the area of poll watchers within this bill. And I think that if we were interested in being able to give second chances to people in other penal crimes by lowering the penalty, I don't see any reason why that we shouldn't be doing that for persons who are doing a civil action. These are civil actions that they are doing, holding the election. So I respectfully ask